specifics of any of those two incidents, or but not going any wider. So what we are asking you to do is to have a think about what could be produced that might meet that narrower position, to engage with the press, who have to be put on notice of what is now being sought, and for us to deal with this as an appropriate moment. We don't want to delay Mr. Hussein's submissions, nor do we want to act with undue haste. It's a bit fiddly. But our instinct is that when we look at the order that Mr. Justice Chamberlain gave, 1C is too wide, and we don't understand why that's there. But the specifics of the incidents, we do think, probably need to be protected in terms of reporting restrictions.
Can we take that away? Of course, I hear what the court has said. That will require us, I think, to have another discussion or a first discussion with counsel for the Crown.
Yes.
In the ongoing cases.
Yes.
So
yes.
may not happen.
Can I just check with my lord? That you're happy with what I've just said? Yeah.
Maybe that's something Mr. Blundell can pick up tomorrow morning.
Indeed, but understandably, we would like to resolve this during the course of the day if we can, and you do need to put the press on notice of effectively what's being suggested, which is a discharge of paragraph 1 of Mr. Justice Chamberlain's order with a varied formulation. I mean, the fact is now we have a full judgment, which is in open from the divisional court, which refers to these two incidents and so on and so forth. Yep.
Yes, I'll just have to take that back to the CPS lot because I don't want to...
Thank you very much. Thank you. Mr. Hussain, ground one.
Ground one. My ladies, just one word about timing.
Yes.
We were supposed to be 2:30. I think Sir James went over by 10 minutes.
He did.
And we're slightly late. Yep. So can I have until around 2:45, so 2:50, something like that?
Well, I think let's sit into lunch if we have to. We do need to...
sure, of course.
We'll see how we go.
Of course. My lady, ground one then. Important...
We have a new skeleton argument, do we?
Sorry. Can I explain what that is? When it comes to fair balance, I'm going to, in the interest of time, just refer to our skeleton. It's not new, save in the sense that it gives you, I think in pink, in red, E references, bundle references. That's all it is, so that I can just not have to spend all the time giving you all those references.
Thank you very much.
Not at all. My lady, so ground one, a narrow point, an important point, we say, headline submission. The divisional court was correct to construe the policy as requiring the Secretary of State to identify a particular need, Div Court at 91, for the proscription of an organisation over and above its meeting the statutory threshold. That's the construction issue. And 2, it was entitled to find that the Secretary of State had failed to do so in this case. On that second question, there's no appeal, and Sir James, I hope it's fair to say, just gave you what he frankly described as a jury point. So I'm not going to spend time on that second question. And my focus of my submissions will be on the construction point. I have 5 points by way of positive case and 5 points by way of response. Positive case, first point. The court, they're short points, you'll be pleased to know. The court observed correctly at 83 that a decision to prescribe requires the Secretary of State to consider 2 distinct questions. First, she must ask whether she believes the organisation to be concerned in terrorism. That's our first question in our skeleton. It's a definitional question. It's a condition precedent to the exercise of the statutory power. But second, the Secretary of State must ask herself whether there's a particular need to prescribe. The second question, a normative question, since, as Sir James himself accepts in his skeleton, 47C, quote, not all organisations which meet the concerned in terrorism requirement would necessarily be prescribed. The fact that there are two stages is very clear from the policy itself. Please can I take you to that supplementary one, tab 24, hard 308, soft 317. So the policy is actually previous page, but the bit that we were looking at yesterday, 308, proscription criteria, heading, what is a proscribed organisation? I asked Sir James to read this because in the final clause of the first sentence, you have an addition. Under the Terrorism Act, the Home Secretary may proscribe an organisation if they believe it's concerned in terrorism. It should be full stop there. But...
Sorry, Mr. Hussain, your bundle references are wrong on the electronic bundle.
I said 317E. 317.
317.
Yes.
Yeah, maybe you... Sorry, okay. I checked a number of your references given yesterday when you were going through quite quickly, and they weren't right. So can we just keep an eye on them? 317 is a good reference.
That's very frustrating to hear. I'm very sorry.
It's okay.
Could we seek to correct if you
don't worry. I've got 317 and I can find them.
I'm very sorry, my lord. That's very frustrating. So 317 in soft, heading prescription criteria. What's a prescribed organisation? Under the Terrorism Act, Home Secretary may prescribe an organisation if they believe it's concerned in terrorism. It should stop there. That's the test in Section 3.4, you'll recall. But what the policy adds is this, and it is proportionate to do so. And then that question is answered at the bottom of the page. If the statutory test is met, then, the Home Secretary will consider whether to exercise discretion. In considering whether to exercise discretion, Home Secretary will take into account other factors, including. Now, I think Justice Lewis said that this is an odd animal. It's a public document. It was something that was presented in substance, that's the phraseology used, in substance presented to Parliament in both annexes to both the March and June Min sub, and we say that the effect is clear that there are two stages. The second point I want to make concerns that second stage, and really this is the fulcrum point for this ground. We say that the court below was right to find at paragraphs 83, 84 and 91 that the purpose of the policy is to constrain the use of discretion. Para 83. 84, it's an additional qualitative threshold. Paragraph 91, the purpose is to limit the use of the discretionary power to proscribe. And that is where we join issue, fundamentally, with Sir James. He says that this is just transparency promoting, if you like.
Oh, don't worry. Thank you.
He says it's transparency promoting. We say it's on a proper objective construction. It's constraining, not a straitjacket. Don't know how many times that term was used. It's not a straitjacket because it's a policy, and you can depart from it for good reason. You can change it if you're the executive. But we know in our modern public law that policies must be followed absent good reason.
So, sorry, Mr. Hussain, I'm having trouble understanding where the constraint comes from in the words.
It doesn't. It's not clear in the words. It potentially comes from proportionate. That's the additional thing in the policy. I accept that when you look at the factors, that they seem open-ended, but the critical thing that gives you the constraint is the context and the purpose. The context is the policy regulating, if I can use that neutral word, let's use regulate for whatever it's doing. We say constrain, he says transparency promoting. It's regulating a discretion which the Supreme Court have said is concerningly wide. If it doesn't constrain, then the policy would enable the Secretary of State to prescribe all manner of organisations that satisfy that broad test. We say that the policy objectively construed, as the court construed it, is premised on a recognition that the definition is very broad of terrorism, the prescription power is very wide. Remember, belief and no requirement as to tempo or preponderance. And the results, very draconian. You put those three things together, width of the definition, see what Supreme Court say about that, the low threshold for proscription, belief, it could be one act out of however many, and the draconian effects, it makes a lot of sense that what the policy is doing is constraining discretion.
Mr. Hussain, looking at the 5 factors,
Yes.
Numbers 2 to 5 appear to be focusing the decision maker on the need to think carefully before proscribing terrorist organisations which have not very much to do with the United Kingdom.
Yes.
Because this is a worldwide power.
Yeah, absolutely.
And a lot of the proscribed organisations are
Yes.
foreign-based. The one that directly addresses an organisation which is only really active in the United Kingdom is really just the first one, which is very broad indeed, isn't it?
Literally construed, yes, but nature and scale. So what my lord, if Sir James is right, you just look at the nature and scale, and you say to yourself, well, it's really not very serious. It's at the outer edge of the spectrum, not part of the essence of the definition, but it falls within the definition. And you've got one act of serious damage to property. So that answers nature and scale. I'm going to prescribe. That's absurd. Think about the BMA organising a doctor's strike, the effect of which is to endanger health, for the ideological purpose of improving NHS provision and influencing the government. Are they a terrorist group? An absurdly wide definition. The function of the policy is to constrain the absurdity of what is a concerningly wide definition being effectuated. That's our submission. So no, I don't accept that objectively construed, properly construed, it is wide, because the wide construction of the first factor gives you a totally perverse result.
So let's assume you're right. The purpose of the policy is to limit use
Yes.
of the discretionary power to prescribe.
Yes.
I'm looking at paragraph 91 of the judgment. What did the divisional court mean when it said any other factor considered when applying the policy must be, quote, of the same nature?
Right, my lady's ahead of me. I want to say that a justum generis we don't defend. Our argument does not depend on a justum generis. The constraint in the policy doesn't come from the nature of the factors, because we accept that the need to promote international relations would give you a reason to prescribe when you might otherwise not. The constraint comes from the purpose of the policy. In that situation, the foreign relations situation, you would have a particular need.
So you don't seek to support that?
Justum generis appears twice, maybe more. It appears in 83, paragraph 83, and it appears in 91. We don't support justum generis. The constraint doesn't come from the nature of the factors, it comes from the nature, the function of the policy, construed in context. Our third point is that the divisional court was right. So basically, we're going to say it got to the right result.
Sorry, can I just be clear? Is that concession in your skeleton argument?
No.
And if so, where?
No, it's not.
And therefore, which parts of your skeleton argument do you no longer
None of them.
assume?
We don't drop any of them.
Right.
Which
parts of the divisional court do you not support?
83 and 91. 83.
It's the activities that comprise the nature... no.
Yes.
The last part of paragraph 83, isn't it?
Sorry, this is apparent from the other four stated factors. This 2, underscore 2. And up 91.
So not activities in the first factor, not limited to terrorism. And...
Sorry, that is something we do defend.
Right. So what do you not defend in paragraph 83?
I've lost my note.
Don't worry. Don't worry, we've got the, perhaps somebody in your team can help you. We have the clear concession on paragraph 91 that you do not support the suggestion that any, quote, other factor must be of the same nature.
It's clearer. Insofar as 83, last sentence, is justum generis, we don't accept it. On activities, sorry, this is a bit tricky and a bit involved. We submit they were right on activities.
Right.
91 is clearer. 91... second and third sentence. While we're on this, can I just review something else that we don't defend? 79 on proportionality. We don't defend the reason the court gave for saying it's not ECHR, for contracting out. We don't defend 79.
Right, so you think it was bank malak?
No. We think they were right in the result. It's broad proportionality. For example, the reasons you were giving, my lady, you haven't got the Article 17 problem. It's bank malak style. We'd always said bank malak style.
Right.
But the reason they gave there, contracting out, we don't defend. Because you can perfectly, with great respect to the court, you can have a situation the executive looks at
what the court might do.
Exactly. So I was on, I think, my third point.
Yes.
The third point is that they were correct to say, and this is the key point, they were correct to say, given the constraining function of the policy as we submit it is, that what you've got to have is a particular need. The factors have got to contribute to explain the particular need to prescribe, above and beyond the necessary belief that the organisation is one.
That's not what the statute says.
No. It's not what the statute says. And the reason... I can completely understand my lady thinking, well, we would hesitate hard before we imposed a presumptive constraint. It's a presumptive constraint, but policies are not rules. You would be slow to impose a presumptive constraint on the exercise of a statutory discretion in normal circumstances, but the circumstances are not normal, because what you've got is a definition that isn't just obviously very, very wide. I hope I'm not going to bore you to death by saying this. The Supreme Court have said it's absurdly wide. Lord Anderson, absurdly wide. Supreme Court, concerningly wide. Legislative narrowing, to be welcomed, can give rise to absurd results. I gave you the example of the BMA. It cannot be right that the policy says nothing about that. It would be very surprising if it did. And what is it doing when it's asking the second question? Statutory criteria met, proportionality. What's it doing if it's not doing that?
I'm not quite sure I understand by what you mean by saying a particular need.
Right.
Now, the circumstances in which the power arises and is capable to be exercised is in Section 1.
Yes.
A public lawyer would read this as that's a discretion.
No, not Section 1.
Or whichever section it is.
Section 3.4.
3.4, whichever it is.
3.3 and 3.4.
Test. It's a discretion, so you have to decide whether to exercise it.
Yeah.
And this says you've got to take into account particular factors. So if they didn't take them into account at all, they'd be acting unlawfully.
It doesn't just say that.
Well, this is what I'm getting at. When you say particular need, two questions. Are you saying something over and above the statutory definition?
Yes, of course. Of course. I'm saying that the Secretary of State has said to Parliament and to the public that I will only proscribe when it's proportionate to do so. And that's the additional bit in the policy. These are the factors that will help me decide that. That was going to be my fourth point. Those factors are designed to help her in answering that question of proportionality broadly construed in the way the divisional court did, i.e., does the benefit of proscription justify the massive cost of it? Now, in a lot of cases, Al-Qaeda, you get to particular need quite quickly, don't you? Nature and scale of activities, nature of the threat, international relations. So, no difficulty. The BMA, not quite. Us, we say they didn't identify a particular need.
So if you need something, is it just, it's not enough that it's serious damage to property, it's got to be serious damage to property, and over and above that, there's got to be something else?
Yes. It's got to be proportionate. That's what the policy says.
But that's not necessarily something, that's not a particular need. I think we all agree, if you're right on Article 17, we're saying there is a proportionality requirement. If that's all you're saying, that's fine. But proportionality does not equate to a particular need.
I'm going to say that the ECHR concept of proportionality doesn't exhaust the idea of proportionality here, because ECHR, it's a floor, not a ceiling, and the common law here goes further, and goes further for good reason, because you could have cases where the proscription is Article 10 compliant, but it's not proportionate in the broader sense. You may have the Article 17 issue. I'm sorry, I'm jumping ahead slightly for some of my points. And of course, your ladyships and lordships will be aware that the Supreme Court over the last 5 to 10 years have been very anxious to establish that, I'm being reminded of the time, thank you, I'd asked for it, have been very anxious to establish that common law constraints and guardrails should not be subsumed by the HRA. This is a common law ground, and my submission is that it makes perfect sense in context for the particular need question to arise.
Is there any authority in support of your proposition? Any authority in support of your proposition in this context?
No, there's not.
And is there, I mean, we know that the policy, so-called, has been applied, I think, since its inception in many, many cases without question.
Yes.
And is there any judgment or decision
there isn't,
that will assist us on this point?
No, there isn't, but I understand the force of my lady's point.
No, it's an open question, I'm just checking.
Descriptively, no, but if there's anything behind that, my answer would be, look at the organisations that have been proscribed. Does one think that a question would arise on the policy as to whether or not there is a particular need to proscribe Al-Qaeda or ISIS?
Well, no, but there's another 96.
Yes.
And we don't know much about quite a lot of them.
First direct action group ever to be proscribed in 33 orders, serious property, damage to property alone. First time. Novel and unprecedented, my lord. We know that.
The other question, you say this is a constraint derived from the content, and you rely on the policy.
Yeah.
And you accept the policy, it doesn't say anything specific about this.
Yes.
So really, why do you need the policy at all? What you're really saying is the statute needs to be read in context.
We had argued Padfield. We'd argued Padfield. My argument was, before Mr. Justice Chamberlain, that Padfield tells you that you can only, Padfield means that you can only exercise this very wide discretion where it is commensurate with the consequences that follow to do so. And Mr. Justice Chamberlain said, put all of that in ground 2. He said ground 6 is duplicative of ground 2. And then your lordships and my lady said, no, it's not.
And just,
do you remember?
Fine, we are conscious of time, and we will now let you just carry on, as it were. But can you give me the cross-reference in your very helpful open skeleton to the floor, not a ceiling, particular need point, because it's my fault.
Right. Floor, not a ceiling is something that I'm afraid I've just
No, but just
said.
The particular need point. Just give me the cross-reference.
Particular need.
Somebody on your team can do that for you.
Yeah, please.
Yeah.
24 to 33. 24 to 33.
24 to 33, thank you.
Specific paragraph, particularly. The fifth point is that the court was correct to hold at 89 that the Secretary of State had failed to act consistently with the policy by failing properly to assess whether there was a particular need. It found that the Secretary of State placed central reliance on an, quote, other factor, namely the general legal consequences of proscription. See Divisional Court at 89. Key matter, it said, an important matter, if not the central consideration, it said at 91. No challenge to that. And the problem with that, as my lady said very early on in this, it is identified by the court at 94. The problem with that is simply a description of the default legal consequences of proscription. They would apply to any organisation.
So I don't think the Divisional Court found that the Secretary of State failed to consider particular need.
Yes.
They didn't make that finding. They said what they did at 91, but what they did find was she had taken into something that was impermissible because it didn't fall within the definition of other factors. That's the key finding
exactly.
in
That's
94.
As you said yesterday, my lady.
Okay.
It's the key finding, and the real problem with that is that if that reasoning is permitted, it would lead to the conclusion that proscription is warranted in almost every case. The policy would not serve its purpose, because you would have those consequences, they apply in every case. So that's the point. It's a narrow point.
And so you seek to uphold paragraph 94?
Absolutely. Okay. And 5 very quick points that I want to say in response. Proportionality I've already addressed. The second point is that we're not being legalistic. All we're doing is applying the policy in context. Tesco Stores Lord Reed says that you've got to do that if you needed authority for that obvious proposition. The eighth point, so it's the third point in response, is the meaning of activities. What does activities mean on the first question? First point is immaterial, as my lady noted. The second point is that you've got
it's immaterial on ground one.
Yes, yes.
It may be material on ground two, in terms of the approach adopted by the divisional court.
I understand that. Yes.
Yeah.
And then the second point is we say the policy isn't regulating a general dispensing power or a general criminal justice power. It's regulating whether you regard an organisation as terroristic. And therefore activities have got to be construed in the light of that and in the light of the statutory discretion which it regulates. The next point was international relations. I've already given you my answer on that, which is, yes, it could mean that you prescribe an organisation you wouldn't do otherwise, but that's consistent with our construction, because that would give you a particular need. And the last point is that it is not the case, that the Secretary of State is precluded from looking at the operational benefits. She absolutely could look at them, provided either they showed a particular need or the other factors did. So those are my submissions. This gone over very slightly, unless there's anything else.
We contributed to the delay, but it's been very helpful. Thank you for answering our questions.
Not at all, my lady. Thank you for asking them. Ground two,
yes.
Schwidler, 30 seconds. Paragraph 46 of our skeleton might be prudent to do what the court says at 163, i.e. apply a review as well as a fresh assessment approach. You've got to have special reasons or compelling reasons. That's all I want to say. And then on the issue of Article 17, scope and less intrusive, Mr. Greenville is going to address you.
Thank you.
Thank you very much.
Yes, Mr. Greenwell.
My ladies, my lords, I will address you, as Mr. Sen said, on two discrete points, Article 17 and scope of Articles 10 and 11, and less intrusive measures. There is quite a bit of ground to cover. I don't propose to turn up many authorities, but I will be providing references as I go. It would assist to have our skeleton argument to hand.
Yes.
I'm going to take as read the general principles which we outline at paragraph 44, namely that the rights to freedom of expression and freedom of association are recognised as fundamental rights, foundational to democratic society, and also, in particular, any measure which consists in the outright dissolution of an association is obviously a very exceptional measure that could only be taken in the most serious cases. Moving to Article 17. In my submission, the Secretary of State is simply wrong when it's submitted on her behalf that Article 17 means that any statements in support of a prohibited organisation, any activity of a prohibited organisation, any activity which amounts to significant damage is automatically outside the scope of Articles 10 and 11 by virtue of Article 17. That's simply, in my submission, an error. It doesn't meet the European case law. It doesn't meet the domestic case law. The consequences of it are obviously stark, because it would take almost everything done by Palestine Action outside of the convention grounds that we rely on. The high point that, in terms of the case law on which my learned friends relied, is the case of Raj TV and Denmark, and my learned friend seeks to derive from that the proposition that Palestine Action are outside the scope of Article 17. Essentially, for the reasons identified by the divisional courts, that's a misreading of that case. My learned friend relied on paragraphs 31 of that case. If one...
So let me just remind you, in the judgment below, which paragraphs, please?
It is in the district court's ruling at paragraph 112.
Yes.
Paragraph
112.
112.
So, on the facts of that case, the organisation concerned was involved in the promotion of the PKK's terror operation. There was repetitive incitement to participate in fights and actions, incitement to join the organisation or the guerrilla, the portrayal of deceased guerrilla members as heroes. And it was not only a declaration of sympathy, but it was essentially propaganda for the PKK. That and it included, and this is the following paragraph cited at paragraph 47, incitement to violence and support for terrorist activity disseminated to a wide audience. Those facts, in my submission, are very different from the present case. And if one looks at the cases cited in the Roj TV case, to give an example of the types of activity which fall within Article 17, it is the cases cited, and this is paragraphs 32 through to about 38. It's Holocaust denials, Islamophobic and anti-Semitic statements. It is statements which not only call for the denial of the State of Israel's right to exist, but call for its violent destruction and the killing of its inhabitants. Those are the sorts of statements and the sorts of aims which put one in Article 17 territory. It also refers to the case of where there is an unequivocal calling for the use of war crimes and summary executions. Those are the sorts of actions which brings one in Article 17 territory. It is simply not the case that any statement by an organisation which is prescribed at domestic law falls within Article 17. My learned friend, in fact, refers to the case of Sabuncu in Turkey. Again, I won't ask you to turn this up, but it's tab 68 of the bundle. And that case, my learned friend referred to earlier paragraphs in that, but he didn't take the court to paragraph 222, which is cited by the divisional court in paragraph 114 of the judgment below. And that says, in terms, that freedom of political debate, which is at the very core of the concept of a democratic society, also includes the free expression by prohibited organizations of their views, provided that these do not contain public incitement to commit terrorist offences or condone the use of violence. So a statement in terms that the fact that an organisation is prohibited as terroristic doesn't put all its statements outside the scope of Article 10. And in fact, that very paragraph goes on to say that it is apparent from the court's case law that where the views expressed do not comprise incitement to violence, in other words, unless they advocate recourse to violent actions or bloody revenge, justify the commission of terrorist offences in pursuit of their supporters' goal, or can be interpreted as likely to encourage violence by expressing deep-seated and irrational hatred towards identified persons, the persons not property, contrasting states must not restrict the right of the general public to be informed of them, even of the basis of the aims set out in Article 10.2. So this establishes it's not only Article 7, that they're not within Article 17 restrictions, it's even Article 10.2 doesn't suffice to restrict the dissemination of those views outside of the calls for violence against persons as indicated. And again, I don't ask the court to turn them up, but we give a number of references in our skeleton argument. It's paragraph 50 of our skeleton argument. Cases are in footnotes 86 and 88. Ekrem Kan in Turkey, Gül in Turkey, Kilik and Eren in Turkey, all cases concerning statements made by prohibited organisations, in most cases the PKK, all cases where the court rejected arguments that Article 17 applied. In fact, in many cases found a breach of Article 10. The position of the Secretary of State is also contradicts with domestic authority. The Court of Appeal has accepted in Chowdhury that offences relating to support for prescribed organisations engage Article 10. The Supreme Court did the same in the case of PWR. The Supreme Court did the same recently in the case of ABJ. And in ABJ, the Supreme Court was taken to a number of the cases relied on by my learned friend, the HTT in Germany case, and so was well aware of those authorities, but at no point said the simple fact that an organisation is prescribed means that Article 17 applies. And so, in my submission, there is simply nothing to the point in the reliance on Article 17. There is.
Are you going to address AG REF, the main authority relied upon by Sir James?
In terms of, yes, in terms of whether the Attorney General's reference, what I might term the Colston statute case, that is a case which turns on whether or not conviction for criminal damage is proportionate. Mm-hmm. It is of very limited assistance in terms of the scope of Article 10 and 11. In my submission, the suggestion that significant damage automatically falls outside the scope of Articles 10 and 11 is incorrect. And in fact, the case where that proposition received greater analysis is the case of Hallam, which was the case in which my lady sat, and it was made
Sorry,
very
which
clear
case?
In that case.
Hallam.
H-A-L-L-A-M.
Made very clear in that case that that it was wrong to conclude that simply because damage was significant, that it would fall outside the scope of Articles 10 and 11. It may well be proportionate to convict someone for an offence of criminal damage. They may not have a defence at criminal law to that simple criminal offence. But that fact doesn't mean that all bets are off, as it were, and that any sentence could be imposed without any risk of breaching Articles 10 and 11. In fact, the contrary is the case. Article 10 and 11 play a role at the sentencing stage, and that's precisely because the conduct remains within scope of Articles 10 and 11. So action which compromises damage to property by itself, not outside scope. Of course, there may be circumstances in which if it's done in a violent manner, that would be different, but simply spraying paint on something doesn't take one outside the scope of Articles 10 and 11. Conduct which causes significant financial loss doesn't take one outside scope of Articles 10 and 11. That case of Trowland, again, another case in which my lady sat. So these cases are all very clear that none of these points on which my learned friend relies means that Article 17 is engaged or that there's any issue of scope here. And there is a very big difference between the proportionality of a simple criminal conviction under the ordinary criminal law for an offence of criminal damage and prescribing an organisation as a terrorist group and all the consequences which follow. So the fact that the former may be proportionate certainly doesn't mean that the latter is. So not only is the points on scope which are being advanced in this court on behalf of the Secretary of State at odds with European law, they're at odds with domestic law, they are also, as my lady noted, at odds with the approach taken by the Secretary of State herself when making her decision, because it was considered that Articles 10 and 11 were engaged, at least in terms of some actions, and that's well documented in the documents in the book. So there is simply no authority which says that damage to property alone puts an individual or an organisation in the realms of Article 17. Not a single European authority for that proposition. Unless there are any questions on that point, I'll move on to less intrusive means.
Thank you.
This, again, is in our skeleton argument. It is at paragraphs 53 to 64. Two headline submissions at first. The first is that the Secretary of State simply failed to identify and consider all of the various alternative means which were available to her short of prescription. And secondly, insofar as consideration was given to alternative methods, that analysis was flawed. The test, of course, is uncontroversial. The test is whether an alternative measure could be used without unacceptably compromising the objective. So exact parity isn't required. There is a degree of flexibility. And our submission is that there were plenty of alternative measures that could be used. We say they could apply as a suite, so we don't have to point to one individual one. And those provided, as the divisional court effectively found, although its reasoning was under fair balance, much of what the divisional court said about the use of the ordinary criminal law also applies under less restrictive means. We set out at paragraph 55 of the skeleton argument essentially 6 different categories of alternative measures. I'm going to address 3 of them. And I'm going to start with criminal prosecution for non-prescription criminal offences. So this is in our skeleton argument. It is paragraphs 55, and it is 55.2. And we list there a number of very straightforward criminal offences which could be used to target some of the actions of Palestine Action. Clearly criminal damage, clearly aggravated trespass, public order offences. It is important that a number of these offences can be applied to those in organisational roles within Palestine Action. It is, for example, simple offences of conspiracy at criminal law apply to those who are organising actions which amount to criminal damage, for example. There is also, and of course, one doesn't have to wait for the criminal damage to occur before arrests can be made, before prosecutions can be brought. One doesn't even have to have specific identified targets necessarily. These measures are used to prosecute sophisticated criminals in all sorts of areas. Sophisticated drug dealing operations and the like are prosecuted under these measures, that they are available and can be used if it is considered necessary to deal with any group which are planning criminal activity. There is also, in relation to statements made, the possibility to bring prosecutions for the encouragement of crime. That's referred to under the Serious Crime Act 2007. There would even be the potential to bring prosecutions for participation in the activities of an organised crime group, if it was felt that Palestine Action even went that far. These are all measures which can be brought in advance of any action being taken by Palestine Action. So that the suggestion that's made in the documents, particularly by the counter-terrorism police, was that these were somehow only reactive measures is simply incorrect. It's perfectly possible to bring these sorts of prosecutions. And of course, a number of the offences I've mentioned are serious offences. They carry serious penalties, and they provide, in our submission, a perfectly adequate response under perfectly normal principles of criminal law. There, as well as the prosecution under the ordinary criminal law, there is the possibility for bringing prosecutions for ordinary criminal offences which are alleged to have a terrorist connection, which it gives the potential for increased sentencing. There are, if it is considered that aspects of Palestine actions cross the threshold into terrorism, there are terrorism offences which can be used which do not depend on prescription. So all of this is available. Some of the objections which seem to have been taken by the counter-terrorism police referred to in the documents provided to the Secretary of State refer to Palestine Action being accused of seeking to stifle a strange justice system and employing legal defence teams to hold law enforcement to a strict liability of proof. That is an unusual submission to make. It would appear that the role of most defence...
Just remind us, we have been taken, you said that the Secretary of State failed to identify and consider. In the submissions to her, where do we find the considerations of alternative, less intrusive measures?
It is primarily, it's in the Min Sub, Supplementary Bundle 1, tab 10B,
Thank you.
page 177
Thank
in
you.
hard copy.
Thank you.
Electronic, I think that's 186.
Yes.
So this is the most detailed analysis that has been provided, but the suggestion that these offences weren't capable or are somehow in principle incapable of addressing the organisational capacity of a group like Palestine Action is, in my submission, simply misplaced. There is consideration of the use of, for example, behaviour orders, which is the second point that I wish to come on to. That is on page 176. Only two forms of behaviour order are cited: criminal behaviour orders and serious crime prevention orders. It is stated that in relation to serious crime prevention orders that they may be made on conviction. That's correct. They can also be made without conviction, so that they aren't dependent on a specific individual being convicted. It is unusual that the objection taken to the use of those orders is that it would require the courts to consider Article 10 and 11 rights before imposing such orders. But how prescription avoids such a problem is unclear, because prescription is clearly a far greater infringement of Article 10 and 11 rights. The advantage of behaviour orders would allow a tailored consideration of Article 10 and 11 rights in relation to particular individuals and their roles. The third alternative measure which I would seek to rely on is that of civil injunctions. And there is simply no evidence at all that this was properly considered by the Secretary of State.
Well, she couldn't get a civil injunction, could she? You're suggesting private law litigation. by third parties at their own cost and risk, assuming they can get the evidence together?
Well, yes, the circumstances in which public bodies can obtain an injunction in support of the criminal law are limited. It would primarily certainly be the private companies that would be doing it, but those private, it is the Article 1 protocol rights of those companies which are in issue.
The Secretary of State has no power to compel any third party to bring civil private law litigation?
No power to compel, but is able to support if necessary, and has supported in the past. The police have provided evidence to private companies in order to obtain civil injunctions. They've been supported in doing that. And it is a measure which has been used, I wouldn't say routinely against protest groups, but has been used again on a number of occasions, and has often had has been very effective at stopping more extreme aspects of protest activity. The recent litigation in relation to Just Stop Oil is one example. Just Stop Oil have stopped their campaign of obstructing highways. A big factor in that were the number of injunctions that were taken out to address that.
There were a lot of prosecutions, convictions and sentences as well.
It's the combination. It's the ordinary criminal law, and we targeted injunctions on particular cases. Those injunctions are a far more sophisticated instrument than prescription, because it addresses the particular behaviour and conduct which is considered to be at issue, rather than a blanket prohibition on the entire organisation. The proceedings for contempt of court can be brought very quickly and can result in very significant prison sentences and very, very significant costs. It is possible to have organisations named in civil injunctions, so it doesn't have to be specifically either against individuals or persons unknown. And there is very little by way of the sorts of behaviours which the Secretary of State seeks to rely on in support of prescription that couldn't also be covered by way of an injunction. And there is, in fact, one example prior to prescription when one site targeted by Palestine Action did obtain an injunction. And the evidence of that is in relation to the Teledyne site. And it is set out in the statement of Kevin Blow. I won't ask...
It's in the judgment as well, isn't it?
Yes.
Yeah.
And the simple point is that there were a series of actions at that site for approximately 6 months before the injunction was obtained. And once the injunction was obtained, activity by Palestine Action effectively ceased. I think there was one action on the date the injunction came into force. So the one time it has been tried, the evidence shows that it's been very effective. And the fact that there is simply no consideration at all of supporting relevant organisations to obtain such injunctions and jumping instead straight to prescription is, in my submission, a very significant flaw in the Secretary of State's reasoning. Unless I can...
You've been very helpful. Thank you very much. Anybody questions? No, thank you very much indeed. Yes, back to you, Mr. Hussain.
Back to me, my lady. I'm very grateful to Mr. Bean for stepping in very short.
Yes, he's done very well. Thank you.
Very kindly, respectfully. My ladies, my lords, fair balance then. I'm going to address you on impact, skeleton, at paragraph 67 to 68. I hope you've got that with electronic numbering.
Yes.
We will give you a skeleton which adds everywhere E-numbers. I'm very sorry we haven't had time to do that
Well, I think that we've come to the end of the road with fresh documents, because we'll now be marking everything up.
Yes, no,
and
you're
I
absolutely
think
right.
we'll just subject to what my
we'll
lord
leave
has
that,
to
sorry.
say. You may want an updated one actually, but
Yeah. What happened is we found out very late that there was this problem. I was working off hard copies, so I'm so sorry. So firstly, impact. Secondly, the Secretary of State's case for proscription. Our skeleton at 69 and also 17 to 23. So we'll look at the decision-making, look at bright lines, violence, escalation, the manual, anti-racism, national security, Brize Norton. And then finally, deference. I'll probably just do that by reference to the skeleton, depending on how much time we've got. Paragraph 70 to 71. The points are perhaps pretty obvious. Before I get to impact, errors in the divisional court, if you do conventional review, no errors, deference, no error as to the margin that was afforded. Second error, Sir James advances, is escalation. Did they fail to have regard to escalation? Our answer is no. Secretary of State was aware of the court was aware of the Secretary's case on escalation. See Divisional Court 3, 34 and 43. The complaint is that Divisional Court 140, they focus on the activities not yet in level, scale and persistence, crossing the line. Persistence, we say, denotes forward-looking as well as backward-looking. The previous paragraph, they were looking at the hypothetical potential for future prosecutions. That's all I want to say. Obviously, none of that matters if you're doing Schwidler. So, impact. So, please can I ask you to keep our skeleton open, or the new document, because that's got the e-references. And I hope the first thing that we've got is paragraph. Yeah. So it's 67, please. I thought you just had the extract. Paragraph 67. I'm going to address you on some of the key categories of people who are impacted. And I hope this chimes with some of the concerns and questions which my lords, my ladies were asking yesterday. So the first category is Judgment 135, Skeleton 67.1, and this is the category of people who pre-proscription were either members or supporters of Palestine Action. Now, Sir James characterised those people as being a relatively small group of hardcore direct activists, implicitly a group that supported acts constituting Section 1 terrorist conduct or acts of violence. But that is just contrary to the evidence. It's contrary to the Secretary's own material. Palestine Action was a group that enjoyed very considerable popular support. Please see our footnote 177 for the references. What did I say? 117, sorry, footnote 117, I'm so sorry. 117, so over 20,000 mailing list and over 500,000 on Twitter, X, Instagram, TikTok. And the ministerial submission accepts all of that. SB1, tab 10, min sub, para 8, hard 146, soft 155. Now, these are people who supported or engaged with or participated in Palestine Action in a variety of ways, for whom Palestine Action was a vehicle for their rights of expression and association. But it's possible further to differentiate this group and to look at the relative impacts on their rights. Those people include people who were, one, consuming and engaging with the educational content which Palestine Action distributed, chiefly about the role of UK-based arms companies in atrocity crimes committed in Israel. Two, includes people who joined in with Palestine Action in conventional, demonstrative, expressive protest activity, so demonstrations and so on. Three, people who engaged in conventional, disruptive direct action protests, which, although we accept, would involve breaches of the criminal law, are unequivocally not the actions of a terrorist group. I'm thinking of lock-ons, sit-ins, blockades, minor damage to property. That's Ammori 1, paragraph 29, supplementary 1, tab 5, page 49 hard, soft is 58. And please remember, as I said in opening, JTAC endorses that. It agrees with it. It says in its assessment, and this is tab 10A, supplementary 1, tab 10A, page 160 hard, soft 169, paragraph 7, it assessed that the majority of Palestine Action's direct action would not constitute an act of terrorism. On the basis any damage to property is typically more minor. Common tactics include graffiti, petty vandalism, occupation, and lock-ons. And then, yes, a fourth category, a smaller cohort engaged in more serious damage to property. So that is the more involved answer, as I put it, to my Lord the Master Rolls question about Lord Justice Leggett, as he then was, and Rawls on the facts. And more serious damage to property has historically not been considered as terroristic in this context. The government has exercised restraint. Whether or not it qualifies as civil disobedience in the Rawlsian sense doesn't matter. The point is that it's been accommodated and treated with a sense of proportion. Criminal, yes. Terroristic, no. And if you were interested in some of the references to the suffragettes, my Lord mentioned them yesterday, you see Professor Hallward, supplementary 2, in the hard copies is volume 3, tab 46, hard 81, sorry, that's just wrong, hard 810, and soft 825, paragraphs 26-27, and then you also have it in Mr. Sam Grant from Liberty, paragraph 5, his second statement, paragraph 5, supplementary 2 in the hard volumes, it's the third volume, tab 57, hard 1035, soft 1050. I will address you on the manual, of course I will. In terms of determining the size of that cohort, the fourth cohort, more serious damage to property cohort, my Lord made the point that the relevant measure wasn't exclusively the number of actions, 3 over 385, but another way of thinking about it, to look at the number of people involved. Now, Tails, the first incident, that's 5 people. Tab 10A, hard 163, sorry, thank you. 163E172, para 25. Para 25.
Sorry, what's that reference to?
5 people at Thales. I'm giving you the numbers.
5 people.
The numbers of defendants involved in the 3 incidents.
Right.
If you're not interested in it, I can do it very shortly. The headline point is going to be, it amounts to about 35 people out of hundreds and thousands.
That's all we need, I think.
Sorry?
I think that's all we need.
That's all you need.
I'm just quite interested in the evidence for that. You gave a reference, but you didn't give me a soft page number.
I thought I did. So Thales is E172, and it's paragraph E172.
E.
Electronic.
Oh, I see.
Sorry, soft.
Supplemental bundle 172.
Yes, sorry.
Yeah, okay.
Paragraph 25. Intra-precision. There are 9 defendants. I'm afraid that's from open reporting. It's not in the evidence. Yep. Sorry about that. And Filton, 24 defendants now. At the time of the JTAC assessment, it was 18. Supplementary bundle, soft copy 171. Paragraph 22. For those of you in hard, it's page 162. The effect of prescription, of course, is the same for all. Their expressive conduct, their association, becomes not just criminal, but terrorist. The obvious inference is this will include thousands. It's not too high to say perhaps hundreds of thousands of people who've never engaged in acts which constitute Section 1 conduct. So that's the first category of people impacted. Pre-proscription members or supporters. Second category, the people who post-proscription campaign in support of Palestine Action.
Hang on. So you're not following paragraph 67 anymore.
Right. I've now gone to 67.3.
Right.
I'm not going to sorry. I'm trying to pick up the sort of.
Okay. So you said you don't want to add to 67.2.
No.
Right. Thank you. Okay. 67.3.
I think I may come back to it. Sorry, I'm going to come back to it. That's a response. So I'm going to come back to her at the end, if I may. So 67.3. People who post-prescription campaign for deprescription of Palestine Action. Skeleton 67.3, judgment 118, we say, divisional court, wrong, respondent's notice point, wrong to allocate little weight to that. This is a cohort of people who, whether or not they were previously members or supporters of Palestine Action, now do support Palestine Action and or wish to advocate for their deprescription. The obvious point is that holding up a placard saying, I support Palestine Action, is, without more, a terrorist offence. It's a strict liability terrorist offence, Section 13. So even if a person might mean, I support Palestine Action, not because they support violence, not because they support Section 1 conduct, but because they support the low-level civil disobedience, which was the vast majority of the actions, or the holding of placards, or the demonstrations, or the consumption of the knowledge about arms complicity, which Palestine Action was engaged in distributing, Section 13 draws no distinction between those people. Intention is legally irrelevant. But it's not just people who are engaged in that kind of classic Rosa Parks civil disobedience. All expressions of support are now criminalised per Section 12. Someone who might wish to say, I think it was a good thing that Palestine Action were inhibiting the work of Elbit Systems because I think Elbit Systems were complicit in atrocity crimes, that's a terrorist offence. Many people agree with, would express support for the actions of XR, Just Stop Oil and so forth, Insulate Britain. Even if those organisations have engaged in or encouraged unlawful actions, unlawful destruction of property, they are free to say that. Not so with Palestine Action. By executive fiat, such expressions of support are now terroristic. The third category in our skeleton, people who aren't, that I want to talk to you about, who aren't members or supporters, but who are subject to chilling effect. So the evidence here...
So 67.4?
Yes.
Right.
Yes. So the evidence is that there are people, many people, are so concerned by the risk of committing or accused of having committed or being arrested for having committed, having work terminated for having committed, any of the offences that they self-censor. And you might think, well, that's fair enough. Serious terrorism offences, it's responsible, indeed rational, to seek to avoid even the accusation of having committed such an offence. But that has very serious consequences for free speech on a matter of the most acute public interest. Concrete examples that we've given you in our skeleton, I'm going to pick out three. Firstly, campaigning civil society organisations. That's our skeleton 67.4. The court below said they faced, quote, general problems. That's paragraph 1, 2, 3. Amnesty's evidence, their concerns regarding proscription offences fundamentally changed their campaigning and advocacy work. It constrained their media work. It limited the encouragement they could provide their members to campaign and take action in relation to civil liberties concerns. Footnote 137 gives you the references. If I can just give you the paragraphs, which you haven't got there, it's 21 to 28. CEO of Amnesty. Liberties evidence, similarly, proscription limited liberties work in campaigning. They ceased public-facing work on proscription, ceased engagement with parliamentarians on the issue, declined numerous media requests, took steps to limit information which Liberty volunteers provided to concerned members of the public. Footnote 138. You don't have the paragraph numbers, they are 18 to 29. The court below were right to accept that those were genuine problems caused by the Section 12 offence. Second class of chilled speech groups. Other groups, this is skeleton 67.5, judgment 119 to 20. We respectfully say wrong to place little weight. Other groups concerned in direct action or campaigning against Israel's violations of international law.
Sorry, which bit of the judgment below?
119 to 120.
Lovely, thank you.
And a couple of examples. Dr. Amy Shalan, she is the chair of the British Palestinian Committee. She described how proscription created a, quote, culture of fear amongst those campaigning for Palestinian rights. Footnote 140. She explained that members of the Palestinian community in Britain involved in campaigning and advocacy work routinely faced legal threats, including allegations of being terrorists or terrorist sympathisers. And that's before proscription. Netpol, this is the Network for Police Monitoring, an organisation seeking to monitor public order, protest, and so on, was overwhelmed by queries from members of the public concerned that their attendance at demonstrations in support of Palestinian rights would fall foul of proscription. Footnote 141. Campaign against arms trade reported contact, again from people in the public who were concerned they couldn't anymore say Free Palestine or display a Palestinian flag for fear of being labelled terrorists. Footnote 141 again. To be clear, the concern here isn't that those concerned members are in fact at risk of being prosecuted, but that the climate that proscription creates means that many, many people will have to self-centre to a greater degree than is actually required. That is chilling effect, of course, in action. Third category, media organisations. Skeleton 67.7, judgment 123, responsible journalists self-censoring on a matter of real and significant public concern. Circumstances of proscription require journalists to take unprecedented editorial decisions where they are afforded no exemption from criminal liability and no guidance in relation to journalists. See the evidence at footnote 147 of our skeleton. That problem is exacerbated, we say, by the overbroad and uncertain exercise of police powers. With respect, the court was wrong to dismiss those concerns. I want to be clear. There's no challenge here to the lawfulness of any particular arrest or police conduct in the material, nor to the proscription offences themselves. But we do submit that the breadth and nature of the proscription offences is relevant to the risk of overbroad police action. That's one aspect of the practical consequences of the decision. First, contrary to the court below at 119, there are particular features that arise in this context which make the possibility for such police errors a particular feature.
And where are you in your skeleton now?
Skeleton at...
is it 67.5b?
Exactly right, thank you.
67.5b.
Yes.
Thank you.
So we say that whether or not a person has committed an offence contrary to sections 11 to 13 can in practice turn on relatively fine distinctions. Was the person's statement an expression of support for the proscribed organisation itself, or merely an expression of support for its aims and objectives, which are shared by that organisation, ABJ 61, which Sir James showed you yesterday? Is the symbol which the person displayed a symbol which a reasonable person would associate with supporters of the organisation, or merely supporters of a broader cause or movement? You say police officers, in deciding whether they've reasonable suspicion, have to make relatively fine judgments. The inherent nature of the offences gives rise, we say, to an obvious risk of genuine confusion. The difficulties are particularly acute in the case of Palestine Action. Loose network of activists concerned about the situation in Palestine, a real risk, we say, very real risk of police being genuinely and innocently confused between Palestine Action and some other non-proscribed direct action protest group. Liberty and Amnesty also make the point in their submissions, para 39, core bundle 36, page 322, soft 476, para 39, and this is a point to which Sir James does not respond, that the effect of section 12.2 of the Act is to criminalise the arranging of a meeting to further the activities of a proscribed organisation. Where a direct action protest group is proscribed, that potentially criminalises any attempt by individuals or organisations to coordinate in continuing direct action protest under an alternative banner post-proscription. That is to say, there's a risk that future direct action on similar matters to those with which Palestine Action were engaged would be said to, quote, further the activities of Palestine Action, to keep it alive post-proscription. Secondly, the second point on this, we say the court below was wrong to say those issues were likely to improve over time and were in any event remedied by guidance. That wasn't a proper answer. Even with guidance, the points about the difficulties arising from fine judgments would continue to apply. In any event, the guidance document upon which the court below relied at 119 is unpublished. It offers no assistance to persons liable to be affected by overbroad policing tactics. They can't know the contents. They can't regulate their conduct. They can't, in the face of wrongful police conduct, rely upon it to avoid arrest. And in any event, the court's approach, we respectfully say, gives inadequate weight to the fact that police conduct in question, stop and search, questioning, more seriously, arrest and detention, all themselves amount to interferences. Then there's a broad point of principle at the end of 67.3 of our skeleton footnote 169. We give you a reference to Lord Bingham in the first Belmarsh case, where he said, his lordship said, that overbroad legislation touching on the liberty of the individual is not saved to be regarded as saved by concession or undertaking and so forth. The issue in that case, Sir James will remember this, the issue in the case was whether the power of internment, which applied to suspected international terrorists, extended to, for example, members of ETA who did not pose a threat to the life of the nation. Lord Goldsmith had given an undertaking in that case to say, well, we won't apply it to ETA, we'll just apply it to ISIS and I think, Al-Qaeda. And Lord Bingham said, no, that's not good enough. The legislation's overboard. And then my client herself, the impact on her, 67.2, sorry to take it out of order. Judgment 122, impact has been severe, resulted in the destruction of much of her life's work, severely restricted her exercise of her Article 1011 rights. By way of illustration, this is judgment 121 and 122. She's been deplatformed because organisers are scared of committing offences. She's been compelled to self-censor. Her every word is now monitored closely. She's very concerned about the risk of inadvertently committing offences under Section 12 of the Act. She's been forced to stop participating in protest activity, a core part of her identity and self-expression, for fear of exposing herself. And that is Ammori 5, supplementary tab 9, paragraphs 9, paragraphs 12, pages 143 and 144 in hard, and 152 to 153 electronic. And also Ammori 1, supplementary 1, tab 5, para 40, hard page 51, soft 60. So those are my submissions on the very wide-ranging and very considerable impact of this decision. I want to now address you, please, on the other side of the balance and look at the basis for the Secretary of State's decision. We see from the MinSub, March MinSub, that the basis was Palestine Action commits or participates in terrorism, 1, encourages, 2, prepare, involved in preparing, 3. And the reference is MinSub, tab 10, paras 12 to 17, hard 147 to 148, soft 156, electronic 156 to 157. Can I please, and we know that 3 actions were assessed under the first limb. So I'm now on commits or participates 3 out of 385, and we have this in the MinSub at para 14 in those pages I gave you. 4 points I want to make. So the 3 incidents, you know, Tales in Glasgow, June 22, Instro Precision in Kent, Sub Judice, June 2024, Elbert in Bristol, Sub Judice, August 2024. 4 points, please. First is that the decision to proscribe Palestine Action was based exclusively on Palestine Action having caused serious damage to property. We see that from the PRG noting at tab 10 in that document, in the MinSub document, at para 10, there's no known precedent of an organisation being proscribed on the basis that it was concerned in terrorism, mainly due to its use or threat of action involving serious damage to property. So James says, well, there's no bright line. Maybe he's exploiting the use of the word mainly. I'm going to come on to that. There's no suggestion there's any other limb, but it's a line of dramatic importance. And if he's right, and there's no bright line, and well, one wonders why he forensically makes that point, but if there's no bright line, then the consequences should not be so consequential. And we might say that the only reason why he can say there's no particular bright line is because the definition is so broad. But it's serious property damage, nothing else.
But when you're looking at national security,
yeah,
damage to property may be a far bigger threat.
Yes. It could
than violence to persons.
No, it could be, and I'm going to address you on the facts. It's property rights with knock-on defence. I'm going to come to that, my lady. But they rely on 3 incidents. It's serious property damage in the form of these 3 incidents, and that's it. And we over 5 years, 385 actions. Why isn't there reliance on anything else? Well, we properly asked, we would answer that by saying, if you look at the contemporaneous documentation, this is the second of my 4 points, the Home Secretary assessed that Palestine Action does not advocate violence against persons. I already told you...
Palestine Action does not
advocate violence I already told you yesterday that that was the assessment in March 25, JTAC, and in the community impact assessment. Would you like me to give you the references again? I gave them to you yesterday.
You can if you want. Yes.
So the references...
We've got them, that's fine.
References are... I'll do it complete. References are JTAC, para 36, 10A, tab 10A, hard 164, soft 173, and then the community impact assessment, tab 10E, hard 191, soft 200.
Thank you.
And I had said yesterday that this was a consistent view before that March assessment, and it remained that view after the March assessment. And I would like you to just take up just a few documents, if I may. I don't think you've gone to them yet. And it's the agreed supplementary bundle. And I think it's the first time that counter-terrorism policing looked at Palestine Action. I think it's the first. And that's the report of 27th of June 24, and that's supplementary 1, tab 17, hard 233, soft 242. And if you could just keep this open, I'm just going to quickly gallop through some of these documents. So if you look, please, at that page, 2/3 of the way down the page, we see Palestine actions very rarely involve offences against the person and are mostly confined to criminal damage investigations. 233, James, to James, and 2/3 of the way down. Have you got it? In between the redactions.
Can you read the paragraph by the first whole bunch?
Whilst not targeting a financial institution, members of PA broke into the promises of intra-position. I'm going to come on to all of this. Of course, going to come on to all this. Intra-position is dealt with. Okay, the next document, please. Tab 18, and it's page 246 hard, 255 soft. So this is a briefing from the National Police Coordination Centre, September 24. And if you look, please...
Sorry, just going back, forgive me.
Yes.
I think that statement about very rarely involving offences against the person was effectively the position before Instro. That's the point. This is a step up.
Well, let's...
Do you see what I mean?
I completely see what you mean, and that's...
Because
I don't think it was. It wasn't.
Well, if you look at what's above, that's I think the point that was being made. Anyway, there we are. You've got another reference.
Sorry, it's a step up. Sorry, no, you're absolutely right. I'm sorry, but the assessment doesn't change.
Good.
That's
so
the point.
Show us that.
Okay. It's the next document, September 24.
Yes.
And it's at page. I think I said page 246,
Thank you.
hard 255, and in soft, and it's slightly difficult to read, certainly for me. It's gisted, and it's at the top of the page, and it says, violence has been observed at 2 direct action incidents in recent months. You see that, and so they're referring there to Instro. The same thing, the same body, says the same thing in December 24 at tab 21, hard page 268, soft 277. They say the same thing at the top of the page. In the second sentence on the page, that we can see. 268 hard. It's this, my lord. 268.
No, I've written something else. I wasn't paying attention.
268 hard, 277 soft. And towards the top of the page, the second sentence that we can see, that violence is not the norm tactic used by PA, despite isolated incidents in 2024 that provoked arrests under TAC legislation. And then the gisting, any violence or harm is assessed to be an indirect consequence of attempts to evade apprehension or has occurred in isolation from a singular lone group nominal.
Mr. Hussain, can I just ask, yes. That's the assessment by the police.
Yes.
What is the respondent's case about that, in fact?
Well,
is she saying that these were two effectively things which happened contrary to Palestine Action's wishes?
Well, I'm not sure that I hope you'll understand obvious reasons why I can't help you on that.
Is there anything in the...
Her consistent position is, I think, across 3 statements, that they have never advocated for violence against persons, harm to persons. I gave you the references.
Yes, we've seen that.
There's no other evidence?
No. But they have never advocated for it.
Never advocated physical violence?
Never.
No. Against people?
Never. Would you? I gave you the references yesterday. Yes, I'll give them now again.
I've got those.
It's quite important that we have that. She's very emphatic about it. And we are emphatic about it. This is not the norm tactic. It's happened. Yes, we can't say very much about it for obvious reasons. It's not, look what the police are saying on their side about this. Never mind what we say, look what they say. And then we see in the June 25 Min sub, at page 222 in this bundle, hard, soft is 231. And this, we know from 233, top of the page, hard 232, this is after the Home Secretary had agreed to proscribe, but she then decided not to do that and requested further advice concerning activity since Elbit, effectively. And so 10 months later, we get the assessment. And the assessment is, at the bottom of that page, activity since August 24, 158 direct action events, different business premises regions. Of those 185 events, 28 have been described as higher level actions, not official definition, damage and cost of repair over £50,000. For example, a lock-on event at a height requesting specialist policing resources and an inner-outer cordon. 159 arrests have been made. So, nothing here about violence against persons, and nothing about serious damage within the definition. So that's the second point I wanted to make. No wonder that all the Secretary of State has about violence is Sir James's advocacy. If she had a case on violence here, it would be irrational, even on the belief threshold, because her own advisors are saying that is not what they are about. So no wonder all she has is Sir James's bright lines, some violence here. That is not this case. This case is about damage, serious damage to property. And 3 incidents and with great respect to the court below, that's all you've got. And as a matter of ordinary analysis, 3 out of 383, they are outliers.
May I just ask you, say 3, the instrument that the Secretary of State ultimately made to prohibit Palestine Action was made after a 4th incident,
right.
Brize Norton.
I'm going to comment.
She put that in her statement.
I'm going to...
A, is she allowed to consider it, and B, even if she isn't, is this court doing a proportionality assessment allowed to consider it?
Yes, you are. I can give you the reason if you're interested, but I think, except you are, I'm going to give you submissions on it. We'll make 3 submissions on it. It doesn't advance the analysis. I'll come on to that in due course. At the moment, I'm interested in her decision-making, if that's okay, in what she was looking at in the documents. And I will address you on Brize Norton.
Well, you can't ignore Brize Norton.
I'm not for a second saying it's what prompted...
But you were saying you were looking at what she was looking at. And she clearly was looking at Brize Norton. Right. She was clearly looking at Brize Norton when she made the announcement.
There's no assessment of what happened in Brize Norton.
No, but she was clearly looking at it, wasn't she?
She was clearly looking at it.
And taking it into account.
The relevant date for analysis of the Article 1011 issue was late November last year. No evidence about that. 0 about Brize Norton. Nothing. No submissions from Sir James that fulfills the definition. Nothing. I can give you the references. Nothing in the divisional court, nothing here. And there are reasons for that. There's evidence about the level of damage. There's evidence about how quickly the planes were flying again. And then there's the history. But please, I don't want to get out of turn. But that's the snapshot.
You're going to come to
3 points.
So at the moment you're on the 4th of June.
Yes. So I was on the second of my 4 points in respect of this assessment. PA commits or participates. 4 points. I've just finished my second one. The third point is that of the 3 actions relied upon, the first, Thales, was 25 months before the decision to proscribe, and the last, Filton, Elbit Systems in Bristol, was 9 months before the decision. We respectfully submit that undermines the assertion made by the Home Secretary on behalf of her that proscription has led to a de-escalation in the seriousness of Palestine Action's activities. That's made in evidence on her behalf. No actions satisfying the definition of serious damage to property for almost 1 year prior to proscription, 3 in the preceding 5. You've got that. And you've seen what I've said about the 158 actions. So Secretary of State says, tell me about post-August, 158, no violence, no Section 1. But I just want to spend a little bit time on the first one of Thales, because that illustrates what we submit with respect is a rather shifting assessment of the relevance of that incident. Prior to the March assessment, the Thales incident had not been assessed to constitute an act of terrorism. That wasn't an oversight. It had positively not been assessed to amount to an act of terrorism. And we have a number of dates, 2 dates that are interesting before and a date that's interesting afterwards. The first date that's interesting before is 19th of April 2023. I'm sorry, I hope it seems to me to be important to spend some time on this. 19th of April 2023, this is a meeting between the policing minister, Chris Philp, and the CEO of Elbit Systems. It's 9 months after Thales. The reference is Supplementary Bundle 1, tab 6C, hard page 90, soft 99. Please go to, and this is a document that my client obtained under the Freedom of Information Act. Please go to page 92. Sorry, 90, first look at 91 in the hard, 100 in soft, and 101. So do you see, second paragraph, although they've been successful, there have been successful prosecutions of Palestine Action members, multiple instances of charges being dropped, defendants acquitted, and then across the page, the next page, the final paragraph before the redactions, Palestine Action does not meet the threshold for proscription as they do not commit, participate in, prepare for, promote, encourage, or otherwise be concerned with acts of terrorism. Now, that remained the view of the government's independent advisor on political violence and disruption, Lord Walney, as of May.
Sorry, you said this was a meeting just...
right. Okay, it's explained, sorry, I should have given you another reference. It's explained in Ammori 2, which is at tab 6, and it's pages 61 to 62, hard, soft, pages 70 to 71. It's explained at paragraphs 35 to 36. Do you see that, my lady?
I'll read it. Paragraph 35 to 36.
Yeah. Oh, yes. She basically explains what that is, what that exhibit is. There. It's a minute of a meeting between Chris Philp and the CEO of
It's not Chris Philp, that's the point.
I got that wrong.
Yes.
Chris Noble, I'm so sorry. Oh, no, it is Chris Philp. Sorry. Paragraph 35, it is. Paragraph 35, Policing Minister Chris Philp.
It's just attendees on page 90 are different.
Yes, I'm very grateful. The document is a briefing note that was handed over at that meeting. The meeting eventually occurred on the 19th of April. The briefing note predates that by a couple of weeks. I'm told that's correct by my own junior Miss Burke.
Was this handed over to Mr. What's the gentleman from
Mr. Fawcett, is it?
Yeah, okay.
I think it's... can't remember. Yes, it's the CEO of Elbit. Now, that assessment remains the view of the government, of the independent advisor anyway, Lord Walney, as of May 2024. And that's quoted, I'm sorry we haven't got that, but it's quoted in our amended statement of facts and grounds. Claw bundle, tab 20, page 1561, paragraph 20, Roman 2. I. Yes, sorry. I mistook my I for a 1. It's page 156I. And then, after the March assessments, we see that as far as the Scottish authorities were concerned, this incident having taken place in Glasgow, they did not think this constituted an act of terrorism. Now, we have that from the Scottish Contest Review Board meeting. This is May 2025. May I please just give you the reference rather than taking it up? It's Supplementary Bundle 2, tab 36A, page 705, hard, 717, soft, and obviously this is well after Thales, almost 3 years after Thales, and it's put pretty emphatically. They say, currently within Scotland, this group has been focused on protest activity which has not been close to meeting the statutory definition of terrorism, despite, in the paragraph above, the Contest Review Board saying Palestine Action has been, quote, extremely active in Scotland, President Trump's golf course and so forth. Not come close to meeting the statutory definition. And then there are points about the value of damage, they were overstated. Just give you one reference. Dewar 1, Craig Dewar 1, paragraph 5, supplementary bundle 2, tab 32, page 665 hard, 677 electronic. That's the third of my 4 points. My last point is that, if anything, the evidence before the Home Secretary was of a de-escalation in Palestine Action's activities in the 9 months prior to proscription, i.e. following Elbit Systems in Bristol, August 24, and it's, I'm not going to turn it up, it's those two NOPC, National Police Coordination Council documents, September and December. In September, they say, since the action on the 5th of August, there's been a reduction in direct action with a focus on solidarity for those arrested. That is tab 18, page 241, hard, 250, soft. And the December document, which says a similar thing, is at tab 21, page 268, hard, top of the page. And that's 277, top of the page, soft. And at 270, hard, 279, soft, 2/3 of the way down the page. And what is said is the number of actions has reduced in December. Despite a reduction in their direct action, they've remained active. Brize Norton, I said 3 points. Secretary of State's case before the Divisional Court was not that the Brize Norton incident amounted to an act of terrorism. See Secretary of State's Divisional Court skeleton, paragraph 59. It relies on the same 3 acts I've addressed above. Core bundle, tab 27, page 278. It's the same in soft, I think.
Wait a minute, please. Thank you. So, page 278, fair balance.
Sorry, my lady. Yes, sorry. Yes, it's soft, it's 432, hard 278, and the relevant paragraph is paragraph 49. So it's not that Brize Norton amounts to an act of terrorism. That's not her case then. It's not her case now. First point. What? It's 59. Did I say something else?
Yes,
paragraph 59.
Yes,
I'm so sorry. That's
no,
right.
I think you said 59. Yes.
The second point is, please look at, in due course, at Mr. John McAvoy's third statement. He's a journalist. Paragraph 7 of his statement, supplementary bundle 2. It's the third hard bundle. Tab 45, page 800 hard, 815 soft, paragraph 7. The 2 planes that were the subject of damage returned to operation within days. And then the third point on Brize Norton is not surprising that Sir James does not make a claim that this amounted to Section 1 conduct, because at least historically it may be that the past is a different country where they do things differently. At least historically, this sort of direct action criminal damage at military bases has not been regarded as terroristic. See, for example, the Jones facts. Jones is famous for Lord Hoffman's quotation at paragraph 89. I gave you references to the facts of the Fairford appellants in Lord Bingham's speech at paragraphs 4 and paragraph 7 from memory. That's Brize Norton. Okay,
sorry,
so
it's my fault. I missed the third point. The first one was not the Secretary of State's case.
Not case. Secondly,
McAvoy. And third?
The third is look at history. Historically, this sort of direct action, criminal damage at military bases has historically not been regarded as terroristic, so no surprise. It's not here. See the facts of Jones. The facts of Jones. Para 4, Lord Bingham. Para 7, Lord Bingham. Okay, so those are my points on the first link. Commits or participates in. Second link, concerned in terrorism, is because it promotes or encourages terrorism. So the Secretary of State says. JTAC assessment, please. Tab 10A, paragraphs 33 to 36, and 35 in particular, pages 164 to 5, electronic 173 to 4. So what is said? It's said the group presents the Filton 18 as political prisoners and has shared statements from Amnesty International and the UN which express concern regarding the use of tact legislation to detain 10 members during initial arrests. And it encourages messages of support. That's what you've got on that there. Our submission is that to suggest that sharing statements from Amnesty and the UN amounts to, quotes, a very serious point, amounts to promoting or encouraging terrorism, does not indicate a serious or credible approach to the statutory criteria. You can just ignore that. It's ridiculous. The third point is that Palestine Action prepares for terrorism.
Just let me have a look at that, given the way you put it, Mr. Hussain. Right. Where are we? Paragraph?
35.
34.
35.
35, thank you. Just give me a moment, please.
Of course.
$37, is that relevant for us or not?
Well, we say what's centrally said there is UN and Amnesty International. They would say the same thing about the property damage in support of their political cause in Kent and Glasgow.
Hold on. So it takes us back to paragraphs 24 and 25. I see. Yep, okay.
Yes, they describe the incidents. So, my lady, I was going to move on to my third point, which is prepares for terrorism. And if you're in that bundle, it's at page 163 hard, 172 electronic. And that prepares, test 2 prepares for, is premised on training and workshops for activists, and in particular the manual. So at last we come to the manual. And that was also relied upon the divisional court, by the divisional court at judgment 24 to 25. Our submission, it doesn't bear the weight which the Secretary of State seeks to place on it. And we have 6 points, very short points. 1, the most significant point perhaps, is that counter-terrorism policing's own assessment was that the mere possession of this manual was unlikely, quote unquote, unlikely to warrant prosecution under section 58 of the Act, i.e. possessing a thing likely to be useful to a person preparing an act of terrorism. And you have that in tab 20 in this bundle, page 264 hard, page 273 soft. And it's in the middle of the page. Palestine Action Underground Manual on its own is an indication of mindset, but mere possession with no further evidence or aggravating features is unlikely to warrant prosecution under that section. The section which is about possessing a thing likely to be useful to a person preparing an act of terrorism. Second point we make is, as CTP said on the immediately preceding stage, is that the manual provided little more than basic ideas around operational security. It's an informal, we say, informal document, slightly tongue-in-cheek if you read it. And this is a report on the 19th of December 2024, 4 months post-Elbit, 6 months post-Instra Precision. Third point, this manual was publicly available. That's Ammori 4, Supplementary Bundle 1, Hard 119, Soft 128, Paragraph 6. Fourth point, did it encourage lots of Section 1 conduct? Well, no. If you look at it, we can see what happened. It was published in August 23, so after Thales, and there were 2 incidents in over 2 years. So you're talking about hundreds of incidents, because we know there were 158 incidents from August 24 to June 25. You need to go a year back, there would have been hundreds. Maybe a couple of hundred. Let's say there was not a single incident then. Still 158 incidents. Nothing after it was published, apart from 2 in over 2 years. And you'll have seen in terms of the action that it recommends, it's not just Section 1 action, it's also spray painting and so forth. Fifth point I want to make is that there's nothing sinister, we say, in the reference to cells. My client, Ammori 4, Supplementary 1, a Hard 120, Soft 129, Paragraph 10. She addresses cells. They're just groups of autonomous people. Autonomous groups of people, sorry. Sixth point, there was evidence before the court that similar manuals by other protest groups have never previously been deemed to amount to preparing for acts of terrorism. The example given is an example from the anti-GM crops movement, and that's Professor Mead, Para 23, Supplementary Bundle 2, Tab 28, 629 hard, 641 soft. So those are my submissions.
Thank you very much.
On the incidents the Secretary looked at and the 3 bases on which she decided that
very good. Thank you.
It was concerned in terrorism. National security. I have 4
You mean deference, yeah?
No, on the facts.
Oh.
4 points. And the first point, 11th of March 2020, obviously limited what I know in open. You'll look at that perhaps on Thursday. 11th of March, FCDO assessment, no significant foreign policy factors. You'll see why I say this in a second. No foreign policy. That Supplementary 1, Tab 10D, page 183 hard, 192 soft. Second point, 13th of March, 2 days later, the record of the PRG meeting. The PRG, this is tab 10D, page 214 hard, 223 soft. The record of the PRG meeting, they discussed the impact Palestine Action's activity on wider UK defence equities, including on UK efforts to support Ukraine. 2 days previously, FCDO had said no foreign policy implications. Third point, 18th of March 2023, note of a discussion between the MOD, the Home
23.
Office... Sorry, 25. I'm getting mad, sorry. 18th of March 2025, yep. Note of a discussion between the MOD, Home Office and Police. Please just turn it up if I may ask you to do that. Tab 23 in the bundle, page 305 hard, and it's page 314 soft.
Three.
It starts at 304 hard,
yep.
Which is 313 soft. And I want you to please look at the next page.
Yes.
If you have that. So the first question is, the question Home Office would like to understand is, what do Elbit Systems UK and other sites regularly targeted produce, and what do they not produce, and for who? We don't need lots of detail, but more interesting, what's the first bullet? Overall impact on defence industry is low by proportion. Impact on individual companies has been large. Fourth bullet, there may be an impact on UK defence industry as a whole, including deterring foreign investment, inhibiting UK ability to supply partners in a live conflict. You've got the FCDO assessment a week previously, and in this document, they're actually asking, top of the page, what is it that Elbit Systems do and for who? And then the fourth point is the Min Sub, 26th of March, and this is tab 10, paragraph 26, page 148, hard, 157, soft. PRG noted the impact of PAG's activity on individuals, organisations and the UK government's strategic defence aims. So they just note the impact. And then on the issue of communication, narrative, they come back to that at paragraph 42B, hard page 151, soft page 160. How to communicate the decision. Min Sub states that communication should articulate the knock-on impact of the UK's defence industry and strategic defence goals. That's what we've got in open. That's it. That's it. The justification for what we say is a colossal impact on individuals, a colossal impact on rights valued not only by the Convention, but deeply valued by the common law. You'll be aware of the Derbyshire Sunday Times decision, famous decision where Sunday Times the Council seek to sue the Times in libel. The House Lords say political speech, free speech, no availability of the tort at all. It's not a defence, it's just not available. Free speech law at common law. That's how important it is. Massive impact, and this is what you've got by way of justification. And racism, anti-Semitism, targeting of Jewish businesses. I gave you two references to Mr. Andrew Feinstein, son of a Holocaust survivor, twice ex-MP under President Mandela in South Africa. He said, nonsense, it's bad reporting, they were targeting a landlord of Elbit Systems. He says, I would never be part of a group, given my history, that was anti-Semitic. I gave you a reference to my client refuting that. The JTAC appeared to accept it. JTAC appeared, they say on their website, they say it's effectively an anti-racist organisation. Paragraph 5 of JTAC, page of that bundle, page 160, soft page 169. Racism, sexual abuse, etc., will not be tolerated. Deference, I'm not going to say anything about. I'm just going to say the points are in our skeleton at 70 to 71, 58 to 59, 69.4 to 69.6. You've got all the points.
Sorry, just going back to your reference to 160, are you
Sorry.
saying that the...
my reference to?
No. Are you saying that JTAC got it wrong when they said... Did they say that Palestine Action... They didn't?
It's never... sorry,
No.
I did it very unclearly.
No, that's fine.
For understandable reasons, Sir James opens with this idea of hate crimes and so forth. It's not their case. It's not a case like Farah Khan, for example. Mr. Farah Khan, who's excluded from the UK.
That was my understanding. That's fine. Just wanted to make sure I correctly understood you. Thank you.
Right. So deference.
Yep.
Please just look at our skeleton.
Yes.
Paragraph 70 to 71, 58 to 59, 69.4 to 69.6.
Very good.
You've got that's all on the issue's impact, they haven't got institutional expertise or responsibility for impact. You've got much more material than they have. Deference that would ordinarily be due in this context, massively attenuated, we say. I'm not going to say anything else. I'm well familiar with it. So that is ground 2.
Good.
I'm going to, instead of doing ground, can I call it ground 3, which is procedural fairness, our first ground on ground appeal,
right.
on cross appeal. Can I please go to discrimination?
Right.
Because it's also Article 10, Article 14. So this is our the second ground we raise in our cross appeal.
Yep.
Rolled up. Appreciate I haven't got permission.
Understand.
Division. The court deal with it in fairly, if I may say so, laconic terms at judgment 143 to 145. We don't accept that the challenge wasn't fully developed. It was significantly developed, both in writing and orally. You see that from the transcript. I know you haven't got that.
No, we haven't.
But our skeleton...
What does the transcript show that it was fully developed?
I pressed them on it at length. I'm reminded. I'm reminded, but I'm told. I was there, I promise you. But yes. No, I remember citing the extract from Lord Bingham in Belmarsh about under-exclusivity and so forth.
Right.
But it was at length, and it was. You won't find it in our main skeleton below, and the reason for that was that about a week before the hearing, Secretary of State tried to argue that we didn't have scope, we didn't have permission,
right.
And Mr. Justice Chamberlain rejected that contention. Secretary of State then said, it was the Thursday before, the Secretary of State then said, well, I haven't put in evidence. So Mr. Justice Chamberlain said, well, you can put in evidence, and you can seek permission to put in evidence, and put in the evidence on the Monday. The first day of the hearing was the Tuesday, or Wednesday. But on the Monday, and on the Monday, they turned up with nothing. They took a decision. They had permission to seek to rely on evidence on this point. They didn't provide any. So therefore, sorry, that's a very long way around saying that our submissions on discrimination were contained in our CMC skeleton prepared for that hearing. And that is Supplementary 1, Tab 25, Hard 347, Soft 346. Below, I mean, you don't need to look at that, but it was there. 356, Soft 356. Before you, more pertinently, you have our submissions. I don't know if you've got the cross-appeal documents separate or whether you in the ancillary bundle.
I've got, anyway, we'll find it. You want us to look at your skeleton
I'm just going to give you a reference. I'm just going to give you a reference. I'm going to make 2 points on legal principles.
Your skeleton of the 20th of March 2026.
Yes.
The replacement application for submission to cross appeal.
Yes.
Yes.
Exactly. and also we address it in the reply as well. Yeah. And in the first document, it's paragraphs 22 to 38, and in the second document, our reply, it's 10 to 17. Legal principles, just very quickly, 2 points, please. You're not engaged, you're not required to identify a perfect comparator. That's obviously well known. Lady Hale in AL Serbia. Please, can I just give you the references? Paragraphs 24 to 25. Authorities, bundle 1, tab 19, page 561. Strasbourg doesn't place any emphasis on the identification of an exact comparator. They ask whether otherwise similar situations justify differential treatment. The comparability test is glossed over. Emphasis is almost completely on the justification test. You said a similar thing, my lady, do you remember in the AB case, and that's the authorities tab 2, authority volume 2, tab 36, page 1302 at 42, para 42, where you said it will usually be convenient to arrive at the question of justification by the shortest route. You reviewed, I think it was from memory, it was Lord Nichols in one of the early cases, but may have been Carson, a few others.
Right, well, anyway, it's of a piece.
That's
yes.
what you did. Anyway, so get to justification. Don't bother too much about similarity. You certainly don't look at exact comparator, otherwise no discriminant level of conception that can ever arise if you're looking for an exact comparator. Second point, what falls to be, and this is very important, what falls to be justified in respect of an allegation of direct discrimination is the difference in treatment. It's the difference in treatment and not the measure itself. The authority for that is the VAT private schools case at first instance, not the case that my lord heard in ALR, and that is Authorities Volume 2, tab 48, page 1732, at paragraphs 128 to 129. In a direct discrimination case, it was the differential treatment that had to be justified, whereas in an indirect discrimination case, the measure was ex hypothesi neutral. What had to be justified was the measure itself. They carve out something in Philiminos. We don't need to get into that. But that's a very, very important point. It was perhaps most starkly illustrated by Mr. Rabinder Singh's submissions, as he then was in the Belmarsh case in July 2002, so Jane may remember, where he articulated the point that what had to be justified was why you weren't interning British nationals who posed the same terroristic threat as foreign nationals did. Classic vice of under-inclusivity. Why are you picking and choosing on a sector or on people who may be politically underrepresented and, relatively speaking, disenfranchised? Very, very important point. You look at the difference in treatment. Why us, why not them, and not the measure. It's terrorism. So everything's fine. Very important point. We make 7 points, please. Would you like me to? You okay
to carry on a bit? Let's try and finish this. 7 points.
7 points. Thank you very much, my lady. 7 points. 1, the Home Secretary's own officials contemporaneously recognised that Palestine Action was similarly situated to other direct action groups employing similar tactics. And it's the CIA assessment in tab 10E, pages 191, and then the key pages are 197 to 198, 206 to 207 electronic, that I want to take you to at, page 191 hard, 200 soft. Okay, so national overview, do you have that? Near the top of the page. Mm-hmm. National overview. HSAI notes that PAG are unlikely to be as well known as other single-issue groups employing similar direct action tactics. Similar direct action tactics, such as justifications XR, are likely to be as well known. And then at page 197, hard 206, electronic.
Sorry, the first page was it 197, 206? I don't know.
Under 3, oh yes, all teams assess it is highly likely. Do you have that? It's in bold.
Yep.
I was missing it. All teams assess it's very likely that a proscription of Palestine Action will raise questions about proscribing other organisations, including single-issue direct action groups, pro-Palestinian activist groups, and pro-Jewish, pro-Israeli groups, with conflicting objectives. The proscription of Palestine Action would likely bring immediate scrutiny to far less environmental anarchist protest groups, particularly XR, JSO, both of which received significant attention in Lord Wolney, and, said again, regularly employ direct action tactics similar to those for which Palestine Action has been brought to proscription consideration. And then the assertion, the rather blithe assertion, back in the document at 193 hard 202 soft, at the end of the page, NCCT, do you have it, asserts that a proscription would likely be viewed positively by the majority of UK communities, instilling confidence that proscription legislation, you've got a whole missing page, is being applied consistently across all groups, regardless of ideology, and reducing the ability of the group to garner support within the UK. An extraordinarily blithe assertion, given what I've already shown you. The court failed to acknowledge, let alone address, this evidence. It was absolutely put to them. Second point. Home Secretary now seeks to disavow her contemporaneous acknowledgement of similarity by contending in her skeleton, supplementary skeleton at 23, that this was no more than a recognition of similarities that may have existed between some of the tactics used by Palestine Action and other single-issue groups. But it is those very tactics, that is to say, Palestine Action's commission of serious property damage in pursuit of ideological objectives, which provided the basis for proscription. That was the point made by the Home Secretary's own officials when referring to organisations that regularly employ direct action tactics similar to those for which PA has been brought forward for proscription consideration. So that's not an offhand comment that those groups employed similar tactics with no bearing on the question of proscription. It was a recognition of similarity for the purpose of proscription. Third point, it is no answer, contra court below at 144 with respect, no answer to the allegation of similarity to say that there was no assessment before the court that those other groups met the concerned in terrorism threshold. Firstly, they appeared to accept they did employ similar tactics, but assume that against us. The fact that there wasn't an assessment is evidence of discrimination, not an answer to it. The Home Secretary can't pray in aid the very discrimination that's being alleged. They're prima facie similar, prima facie employ similar tactics for the purposes of proscription, but hey, there's no actual assessment. Well, that's not an answer. It would be a very bad day for the discipline of equality law if that was allowed to pass muster in a context as anxious as this. Fourth point, there was extensive, objective, uncontested evidence before the court. Even if all of that's not enough, the own assessment isn't enough. Extensive, uncontested evidence which indicated that other groups, both contemporaneous and historic, had carried out similar actions, caused similarly serious property damage in the course of their protest campaigns, who had never been proscribed. And I'll just give you the references, if I may. It's Professor Mead, Supplementary Bundle 2, tab 28, page 623. That's hard. Electronic is 635. And please just cast your eye in due course. I don't have time to do it now. Paragraphs 4, paragraphs 5, XR and JSO, paragraph 6, financial institutions, paragraph 7, JSO and XR, government buildings, and so forth. Professor Rogers, Supplementary 2, tab 29, hard 633, electronic 645, and then Mr. Deshmukh too. He's the CEO of Amnesty. I've already referred to him. Supplementary 2. Is it actually supplementary? No, it's supplementary 2, hard copy, supplementary 3, tab 56, page 1024, hard, 1039, soft. Paragraphs 12 to 13, Animal Liberation Front, property damage, letter bombs, incendiary devices, harassment, intimidation. Paragraphs 14 to 15, munitions, trident ploughshares, that's the Jones case. Paragraph 16, climate change, XR, JSO, insulate Britain. Paragraph 17, this is what I referred to as the punchline yesterday. The forms of activism that PA has been engaged in are not new, are equivalent to, in some respects, lesser in terms of severity than forms of activism haven't been treated as terrorist. The court below, with great respect to them, failed to address this evidence in any way whatsoever. It's just simply wrong, perverse, with great respect, to say there was no evidence of conduct capable of satisfying the serious property damage definition as regards those groups. Fifth point, no attempt whatsoever by the Secretary of State to justify this difference in treatment, whether contemporaneously or in evidence. The closest thing that we get is that blithe assertion I took you to. It's really not good enough and quite concerning. Right? No, we submit. No attempt at justification in the evidence. We go back to Mr. Justice Chamberlain the week before the hearing. It's not in scope of your permission decision. Yes, it is. We haven't provided evidence. Okay, well, you can try to do that. Do it. You've got permission to apply it to me to put in evidence on the Monday. Nothing. And you see that in the order of the 21st of November. That was when it was sealed. The hearing was the previous day. That was the Thursday. Supplementary 1, tab 26, hard 353, soft 362, paragraph 2. She could have put in evidence. She had permission to try to put in evidence. She chose not to. The sixth point, the court below at 144 is wrong, we say. In fact, profoundly wrong with great respect, to say that the Home Secretary was entitled to consider the case for proscription on its own merits. With respect, that contention completely misses, is profoundly antithetical to the very foundations of equality law. And I just want to take you to one passage in Belmarsh, please, and this is in Authorities, Volume 1.
So paragraph 144 of the Divisional Court's decision is profoundly wrong.
Because they said that the Home Secretary can consider the case for proscription on its own terms. Presumably that means, like, you don't have to worry about comparing. You just look at whether they fulfil the definition, it's proportionate. That's Article 10 and 11.
Right.
What about 14?
Okay, so, and then you want to take us to
Belmarsh, which is tab 16 of Authorities 1, and it's Lord Bingham endorsing at page 414, it's at letter H, Article 14, paragraph 46 of Lord Bingham, well-established obligation in the state not to discriminate, etc. And then over the page, so this is page 415, Professor Hirsch Lauterbach, the claim to equality is in a substantial sense the most fundamental of the rights of man. And then Mr. Justice Jackson in Railways Express, and he says towards the bottom of that quotation, the second half, there is no more effective practical guarantee against arbitrary and unreasonable government than to require that the principles of law which officials would impose upon a minority must be imposed generally. Conversely, nothing opens the door to arbitrary action so effectively as to allow those officials to pick and choose only a few to whom they will apply legislation, and thus to escape the political retribution. Remember, they're less well known. At the beginning of that document, they're less well known, to escape the political retribution that might be visited upon them if larger numbers were affected. Courts can take no better measure to assure that laws will be just than to require that laws will be equal in operation. Quite so. Why was it that Palestine Action was chosen, out of other groups whom the Secretary of State herself accepted employ similar tactics?
Right, and your final point?
Final point.
In your
sorry.
final minute, Mr.
Final
Hussain.
point. Sorry, thank you so much.
No, we've done very well, and we, I think, are now in parity in terms of time and on track for a 2:30 handover.
Her submission, the Secretary of State's submission in her skeleton, that prescription decisions turn on a broad-based, multifaceted, nuanced assessment which considers a consideration of discretionary factors. With respect, there's nothing in that point. Many decisions involve that sort of assessment. That doesn't place those decisions beyond the reach of equality law. The logical consequence of the submission is that you could never have an equality assessment of a prescription decision, and that can't be wrong. That can't be used to escape the fact, in any event, that no assessment whatsoever was conducted. Those are my submissions.
Well done, Mr. Hussain. You've made good progress. So we just have duty to consult.
That's right.
Left, and then we'll be back with Sir James. Thank you all. I suspect you all want a break, but I would like to make sure that we are on track to do something about reporting restrictions at the end of the day. Is that going to be the case? All right. All right. Thank you all very much. 2 o'clock. Yes, apologies for the slight delay, Mr. Hussain.
My lady, so our first cross-appeal ground, due process, addressed at 47 to 67 of the Divisional Court. In our submissions, it's addressed in our cross-appeal submissions, paras 4 to 21, and in our reply at paragraphs 2 to 9. May I please address you on three broad topics. Firstly, pretty quickly, the legal principles. Secondly, the application of those principles to the facts here. And thirdly, I'm going to try to draw together the ways in which the court erred in this case.
Okay, but we would like you to finish by 2:35, no later.
Oh, yes. Okay, so part one, legal principles. 4 preliminary points, please.
Yes.
1, the starting point and fundamental rule of the common law is that a person adversely affected by a decision, certainly with draconian effects, is to be informed of the case against them and given an opportunity to answer that case by evidence. It's a fundamental rule in the sense that it is one of the oldest principles of the common law. We'll see that from Lord Sumption in Bank Mallet. It is a rule that's so important that its abrogation must be clear from the legislation, Lord Neuberger and Bank Mallet. And indeed, ouster can only arise in the statute by way of necessary implication, something that is different to expediency, even desirability, or even reasonable implications. See my lady in Begum. Where the statute hasn't ousted, it will be rare that the facts do so because of the importance of the duty. Lord Neuberger in Bank Mallet. The second preliminary point, I've said that it's important and what that means in terms of statutory construction. Why is it important? Very well known, Osborne. Firstly, instrumentally, it produces better decision making. Secondly, it treats the individual with respect and dignity. Lord Reid citing Jeremy Waldron. And thirdly, it promotes the rule of law. Lord Reid citing Lon Fuller. The third preliminary point is whether procedural fairness has been observed is, of course, a matter for the court to determine for itself, not a matter for the judgment of the executive. You have Osborne is one of the cases you don't have, but it's in Osborne at paragraph 65. It's perfectly obvious. It's within your institutional competence and indeed your constitutional responsibility to uphold the rule of law. Fourthly, it is an important part of the legal landscape here that the court held in the preliminary issue on alternative remedy that sections 4 to 5 of the Act are not, quote, and are not intended as a means of challenging the lawfulness of the initial decision to prescribe. That's your judgment, core bundle, tab 24. In the hard copy, page 179, AL, page 179 AL, in the PDF soft copy 316, paragraph 51. This is important because, as we will see, the availability of a statutory appeal to SIAC was central to my lady's conclusion, my lady's apostrophe conclusion in Begum, as to why the standard and fundamental rule didn't apply in that case. It's also important because the Secretary of State strongly relied upon those sections, POAC, both in submissions and in evidence. In her contention that the statute ousted the fundamental rule, it's the first point made in her detailed grounds of defence, paragraph 82C core, bundle 25, tab 25, page 213 hard. E is 367, thank you, Mr. Luckhurst. Soft is 367. It's also relied upon in Mr. Sinclair's second statement, Sinclair 2, paragraph 8, supplementary bundle 1, tab 4A, page 42D hard, 46 hard. 42D hard, 46 soft, sorry. They say, POAC. If you strip away that erroneous premise of POAC, we can see that there's nothing in the statute that ousts necessary implication, the fundamental common law rule. Those are my 4 preliminary points. 2 authorities, Bank Mellat and Begum. Bank Mellat, please, can I ask you to take it up? It's in Authorities 1, tab 22, page 696. So at the beginning of the judgments in the main appeal, not the closed material procedure. Is, you will know, financial restrictions designed to counter nuclear proliferation, 6-3 majority decision that the Treasury's decision was vitiated by procedural fairness. As usual, my lady is ahead of me. Paragraph 29, yes, the duty Lord Sumption. Paragraph 29, apologies. Duty to give advance notice, opportunity to be heard against to a person who, against whom a decrepit statutory powers to be exercised, one of the oldest principles, and then citing Cooper.
I'm sorry, Mr. It is our fault, but we are finding it difficult now to locate which paragraph you're currently reading in Bank Mellat. I'm so sorry.
I'm sure it's
29.
29.
39.
29.
29.
29. 707. Oh, so these references. Okay. Thank you.
29.
Paragraph 29.
Page 707.
Page 707, thank you. And then paragraph 31, page 708, paragraph 31, unless the statute deals with the point, the question whether a duty or prior consultation cannot be answered in wholly general terms depends on the particular circumstances. And then paragraph 31. 35, the duty of fairness governing the exercise of a statutory power is a limitation on the exercise of the decision-maker, discretion of the decision-maker, which is implied into the statute. In fact, the statute makes some provision for the procedure to be followed before or after the exercise of the power doesn't of itself impliedly exclude that duty. And then at paragraph 37, Lord Sumption, JR doesn't exclude. It would be surprising if the statute did. We're a fortiori, of course. And then I'm going to jump forward, if I may. That's all I need from Lord Sumption. I'm going to jump forward to Lord Neuberger at page 750. And this is paragraph 179 of the judgment. Now, this is important because this was common ground that this is the test, this represents the law, and my Lord Justice Edis will recall a case in which the Secretary of State sought to draw clear blue water between Lord Sumption and Lord Neuberger, and your Lordship held no difference. 179 is controlling. It's the case of Timpson, in which your Lordship held that some time ago.
Thank you for reminding me.
179. In my view, the rule is that before a statutory power is exercised, any person who foreseeably would be significantly detrimentally affected by this exercise should be given the opportunity to make representations in advance unless, 1, the statutory provisions concerned expressly or impliedly provide otherwise, or 2, the circumstances in which the power is to be exercised would render it impossible, impractical, or pointless to afford the person such an opportunity. And then you've got to be slow to do it on Roman 2, given if you've got to that stage and Roman 1 hasn't been excluded. And then just going forward to 191, para 191, page 752, letter G, just above letter G. At a high level, I consider that while the right to be consulted in advance about the exercise of a statutory power, which will cause significant harm, can be abrogated by implication or statute in the statute, that right is so important that the implication must be very clear. That's all I want to take from Bank Mellet. National security context, affirmative resolution procedure, statutory instruments, not relied against us. Clearly, due process applies in both those contexts. 6-3 majority. We now go to Bagan, please, if I may. Case which will be well known to my ladies. That's Authorities tab 37, Authorities Hard Volume 2, tab 37, page 1309. And you'll see how the issue is framed. The case, of course, is one of those unusual cases where the provision of a merits appeal combined with the legislative purpose and context in which deprivation decisions on national security were typically made, people who were abroad who might preemptively come back, meant that there were, quote, compelling reasons for holding that the basic common law right to be heard was impliedly excluded. You'll see how the issue is framed. It's framed in line with Lord Neuberger at 191 in the implication of ouster must be very clear at 104, where you're dealing with 104, page 1339, you're dealing with ground for a due process. And you look at the proper approach to statutory construction, letter E, asking ourselves whether Parliament has by necessary implication excluded a right to prior representation. Then you cite Morgan Grenfell, Lord Hobhouse, the legal professional privilege case, powerful, pithy expression of what that means. It's a matter of logic, it's not reasonable. Necessary is something much more than that. At paragraphs over the page, 106 to 107, so sorry, bottom of the page, and over the page, a main, if not the main purpose, which displaced the common law rights so that the general rule was no prior consultation. National security in general was the main purpose, but it was important to see how that main purpose was to be implemented. Deprivation decisions in the context of people abroad, to notify a person abroad of an intention to remove their citizenship could obviously act as an encouragement to that person to return to the UK preemptively. The very act of seeking representations would be contrary to the national security of the UK. The individual would take immediate steps to return. So it's in that context that the general rule is endorsed. There's no general rule that in national security across the board, wherever it might be engaged, there's a general rule of no due process right. That would, it's wrong. There's no case which says that, and B, it's inconsistent with Bank Mellet and Lord Neuberger. That is a national security case. But in other words, in Begum, the relevant risk was of preemptive action to deprive the order of its effect, travelling back to the UK while the individual is still legally able to do so, so that the objective of keeping him or her out of the UK is frustrated. The same logic just doesn't apply here. Whatever Palestine Action did in the intervening period, they would be subject to the very same consequences on prescription as if they had not been consulted. There's no analogy with travelling back.
You say Palestine Action has to be consulted, but I understand it's not a body.
I'll address you.
The question is, which
my
person
client.
or person?
My client.
One of the two co-founders or both the two co-founders?
One would be sufficient,
Right.
yes, and they knew that they were spokespeople. The email addresses were there in the press. I'll address you on that. There's no analogy with travelling back, as in the UK deprivation cases, by which to contend that prior notice was depriving the measure of its intended effect. The context is that surprise was of the essence and paramount. There's a huge contrast here, because the statute contemplates notice, except not in the common law rule sense, but except in urgent cases, because it says affirmative resolution only effective if approved by both houses, save in urgent cases. So the statute distinguishes between cases it regards as urgent, immediate effect, unless disapproved by both houses, and the standard case. And we are in the standard case territory. There's a point, in fact, that Mr. Justice Swift made an argument. I was looking at the transcript, well, he ruled against us, but he said, look, the statute contemplates time that the group is aware it's going to be prescribed. There's very different statutory context from Begum, where surprise is of the essence. And you set that out at 108 to 109. 109, SIAC had agreed that the statutory code wasn't enough. It applied simplex, it applied we don't need to get into that, if you remember. And you said, in the light of Bank Mallet, that might be so, that it wasn't enough to exclude. You place critical reliance, we submit, my ladies, critical reliance on the appeal to SIAC, because they had underrated, quote unquote, it underrates the distinctive nature of an appeal to SIAC. It's absolutely critical that you had that appeal to SIAC in this decision. And then at 110 to 111, you discuss SIAC, and then at 112, you said the existence and distinctive nature of this right of appeal and the risk of preemptive action by the appellant, if prior notice given, remain, in our view, compelling reasons to construe the statute as excluding the common law rule. 3 points of distinction. POAC, not an appellate merit review, it's JR. It's not available anyway. Secondly, no analogous risk. Thirdly, no compelling reason to exclude in the statute. Indeed, on the contrary, the statute contemplated notice, the reasons I've given. Topic 2, I'm going to speed up. Topic 2, application of the principles to the facts. Lord Neuberger, 179, no express ouster, no statutory appeal, no necessary implication, we say. Do the circumstances mean it's impossible, impractical, or pointless? No. 4 points. 1, who to consult. Our cross-appeal skeleton at 19, please. If you just have an eye on that. My client is co-founder. JTAC assessments show that she's viewed as a spokesperson, one of the spokespeople for the group. The references at paragraph 19 of our skeleton. And they're twice described that. Making contact would have been straightforward. We make the point in our skeleton at paragraph 19 that Palestine Action provided an email address for information and queries. Second point, what information and allegations could be put? We can see from the extensive open disclosure in these proceedings that this wasn't a case in which national security prevented the Secretary of State from putting the gist to my client. Third point, the factual chronology shows that proscription wasn't treated as so urgent as to render consultation impractical. We've set it out, the chronology, with cross-references at paragraph 17 of our cross-appeal skeleton. Direct action 5 years before, last incident in terrorism, August 20, as assessed as terrorism, August 24, and then most saliently, when the decision is made on the 20th, the written statement is put into Parliament as announced 3 days later on the 23rd. So it's in the media on the 20th. If you don't accept that, it's there announced on the 23rd on the Monday. A draft order isn't laid until another week, and then it's not passed into law for about another week on the Saturday, on the 5th of July. So we've got 2 weeks where we know. On the facts, this was not approached with any urgency or on the basis that surprise was of the essence. Fourth point, as to the risks of preemptive action, this isn't a Begum-type case. This is my fourth topic. First point, not Begum-type case. Secondly, I've already made the point that we had at least 2 weeks' notice. Third point, no specific evidence of a risk of preemptive action. Secretary of State, in her skeleton, relies on a generic issue in the explanatory memorandum. Sir James also relies on Sinclair 2. Again, that's entirely generic. In his oral submissions below, he talked about a possible issue regarding the movement of funds. In evidence, that's the generic issue that's made. That hasn't reappeared before you. But in any event, we know from the open material that Palestine Action is primarily funded from small online donations, and they could have disbursed money, if that was the concern, in the 2-week notice they had. Errors in the reasoning of the divisional court. I'm going to ask you, please, just to have reference to para 12 of our skeleton. We've set out 7. 2 of them I've dealt with at the end. reasons 6 and 7. I'm just going to address you quickly on 5. 1, the court applied the wrong test, judgment 58, in saying that the national security context meant that a court should be cautious to supplement these procedural requirements. That's not the test. The correct question isn't when the court should supplement the requirements, is whether the statutory provisions expressly or by necessary implication exclude the common law duty of prior notification. That is the modern law. It's the modern law, Supreme Court Bankmallet, this court in Begum, if you need it, Lord Brown-Wilkinson in Pearson, principle of legality type analysis. Second point, the court below effectively reversed and conflated the two-stage test, Lord Neuberger 179. It didn't ask whether the common law duty was excluded by statute and then consider particular circumstances of the case. Instead, and this is really, with great respect, a really deep error, for reasons I'll explain in a minute. What it did is it asked itself whether there might be hypothetical circumstances in which compliance was impossible or impractical with the common law rule. And it reasoned that because there could be such circumstances, theoretically, the obligation didn't arise at all. It used the circumstances of hypothetical cases, not this case, to answer the first Bankmallet question on statutory construction. That is deeply problematic. It's deeply problematic because if you put Lord Neuberger 179 Roman 2, particular circumstances, into Roman 1, Roman 2, the particular circumstances test becomes otiose. It has no application. Secondly, we rhetorically ask, how could hypothetical circumstances supply a necessary implication of exclusion? The third point we make is that as a consequence of this misdirection, it didn't make any finding on the exclusion issue. Necessary implication, exclusion. Fourth submission is affirmative resolution. Mr. James doesn't rely on that. Mr. Justice McGarry, 1978 case called Bates, doesn't apply. Modern law's moved on, where you've got a particular affirmative resolution measure which targets an individual, which is what we've got here. That's Bankmallet. He doesn't rely on it. Fifth and last point, the court was wrong to find, this is really illustrative of a very deep error with respect, was wrong to find that any decision to require further procedural steps in this case would necessarily apply to all other occasions when the Home Secretary was considering use of the power to prescribe. Your lordships and ladyships can conclude that the obligation applies in the present case, but conclude in a different case that it is excluded under Roman 2 of Bankmallet 179. Particular circumstances are picked up case by case. The first question is, does the statute necessarily exclude?
Yes, I think we've got that.
So, and then the point hasn't been made about materiality or anything like that, or Section 31. We had a colossal amount to say. My client's statements illustrate that, but just I can give you two examples. Fails. One of the incidents of terrorism relied upon by the Secretary of State. My client could have said, hang on a minute, your police minister in 2023 had assured Elbit that this is not terrorism. That's one example. So, another example is, we are an anti-racist organisation, but that's not really, there's a lot to say. It's not necessary, in this, certainly, except in extreme cases, that you disapply this fundamental rule on grounds of no difference or highly likely not to make any difference.
Well done.
More or less bang on.
Very good. Well done, Mr. Hussain. Thank you very much. Any questions from anybody else? Any? No, thank you very much indeed. Thank you to everybody on your side of the court. Sir James.
My Lords, the proposal is in fact that I should address.
Right, very good.
Subject to and then Sir James will have a free run.
Very good, thank you. Article 14.
Article 14. We respectfully submit the Divisional Court was right to reject this ground of challenge and right to refuse permission to appeal. Our essential submissions are that the Article 14 challenge faces a series of what we would characterise as insuperable hurdles, and even if you decide each of them in the respondent's favour, the ultimate Article 14 question collapses straight back into the issues you would already have resolved under Article 10 and 11 in the main appeal. In essence, the ground adds nothing, as indeed was the observation of Mr. Justice Chamberlain back on the 4th of July in his interim relief ruling, paragraph 71, Authorities 2, tab 47, page 1647. At best, we submit the Article 14 ground gets to the same place by a route which is both circuitous and legally uncertain. The two bases on which the Article 14 argument is advanced, one developed orally, but I'll deal with both, of course. Firstly, direct discrimination on the grounds of political opinion said that the decision was taken to prescribe Palestine Action, but other, quote, protest groups using direct action for other causes were not. The second, indirect discrimination, here targeting the effect of prescription, which is said has caused disproportionately prejudicial effects on those of Palestinian ethnicity, national origins, and or nationality. Starting with the claim, then, of direct discrimination. Our first objection, my ladies and my lords, is that the respondent cannot establish an analogous group or relevant cohort as a comparator under Article 14. The principal reason for that, we submit, is the nature of the decision-making here.
Sorry, you're dropping your voice.
The nature of the decision here.
Right.
We are concerned here with the discretionary power exercised on a case-by-case basis following a multifaceted, individualised assessment. Each prescription decision is taken on its own distinct, fact-sensitive basis, which is either justified as an independent exercise of the prescription power, or it is not. The nature of that exercise that we are dealing with here, we respectfully submit, stands in contrast to each and every one of the Article 14 cases that are before this court, both domestic and ECHR. A very short summary of each of them. We don't need to turn them up. But in McLaughlin, Volume 1, tab 26, page 886, the challenge was to legislation denying widowed parents allowance, but as the claimant had not been married, although had been together for 23 years. SC in the Supreme Court, Volume 2, tab 31, page 1050, the two-child limit introduced in 2016 to the Tax Credits Act 2002. AL Serbia, Volume 1, tab 19, page 551, a concessionary policy applied to certain asylum seekers who've been in the UK for 3 years or more. AB, that I know my lady, the Lady Chief Justice and my Lady Justice Whipple are very well aware of, the Afghan prosecutor claiming discrimination given the differences between the policies on biometric data with reference to Afghanistan on the one hand and Ukraine on the other. And ALR, of course, legislation removing the VAT exemption for private education. Those both in Volume 2, tabs 36 and tab 48. All of them challenging legislation and or policies. The same exercise can be undertaken with respect to the ECHR authorities as well. The short point, as identified by the Grand Chamber in Carson, we have at tab 52, page 1949, paragraph 51, is, as is said there, as with all complaints of alleged discrimination, it is concerned with the compatibility with Article 14 of the system, not with the individual facts or circumstances of the case, and see to the same effect the observations of this court in AB. Article 14 challenges are about differences in treatment between cohorts in relatively similar situations. They do not involve individualised assessments. That's paragraph 57, volume 2, tab 36, page 1306. Here we submit we are dealing only with a series of individualised assessments made on the basis of the discrete facts assessed on a case-by-case basis. We are not, we respectfully submit, in the territory of cohorts or systems, rules, or measures. I should add, we were taken this morning to the Belmarsh case, which is in our authorities bundle. That, of course, was a challenge to Section 23 of the Anti-Terrorism, Crime and Security Act 2001. So again, a challenge to legislation. We respectfully submit that what you cannot do in this context is seek to establish a cohort for Article 14 purposes by isolating one aspect of the factual matrix, i.e. the concerned in terrorism test, and pointing to other groups who might share that characteristic but are not prescribed. We submit that if that were permissible, then the burden on the Secretary of State would be, in practice, impossible to discharge. Test that we respectfully submit in this way. The most recent challenges before POAC to prescription have concerned, the two most recent have concerned the Tamil Tigers. That is the only organisation in Sri Lanka that has been proscribed. There are, though, no doubt, other organisations in Sri Lanka that are, quote, concerned in terrorism. Islamist extremist groups, no doubt, I assume, right-wing, left-wing extremist groups, etc. Some of those may well be concerned in terrorism themselves. Indeed, some other organisations have been identified by other jurisdictions as terrorist organisations. And of course, given the nature of terrorist activity, which inherently has a link to the purpose of advancing a political, religious, racial, or ideological cause, you're necessarily going to be in a realm of categorisation that engages Article 14. But the fact we submit that the Secretary of State has only prescribed the Tamil Tigers can't give rise to a complaint by reference to other organisations that she hasn't prescribed on the grounds of Article 14. And indeed, the working assumption must be that there are such other organisations, because others have identified them as terrorist. That would be an impossible burden, and it undermines, we respectfully submit, the flaw in the respondent's analysis, because this discretionary power to prescribe is not exercised against Group A instead of other groups, Group B, etc., or even exercised by reference to an overarching analysis that looks at all the actions of all relevant groups as a whole, and then decides only to prescribe some of them, and still less is there a commitment or policy to prescribe all groups concerned in terrorism. Instead, as I've said, each is taken on its own distinct fact-sensitive basis. And we respectfully submit that that is the beginning and the end of the Article 14 analysis, quite rightly identified by the Divisional Court in its judgment at paragraph 144, the Secretary of State entitled to look at each organisation on its own terms. Even though if you were against the Secretary of State on that position, we respectfully submit that the materials that are relied upon to demonstrate that there is a comparator here, materials relied on by the respondent, do not establish a comparator for the purposes of Article 14. The highest the case can be put for the respondent is by relying on the community impact assessment. We have Bundle 1, Supplementary Bundle 1, 10E, page 191, electronic 200. The only references that you'll see there, and they're on page 191 and pages 197 to 8, are electronic 200 and electronic 206 to 7. The only references that you'll see there are references to similar direct action tactics. That was rightly recognised and properly recognised by the community impact assessment and those who conducted the report. But the short point is we submit that none of those observations are sufficient to establish a comparator for the purposes of Article 14 in this context. None of them amount...
Can I just check?
Of course.
In putting it into the framework, yes, you can go straight to justification, but if you stop at the various groups, justifications on group, one issue is whether or not groups were in a materially analogous position.
That's right.
And that's the bit that you're relying on in relation to Just Stop Oil and the other ones, is it?
That's at the moment, yes. I'm going to get to justification as well.
I appreciate that, yes. But at the moment, when you say no comparator, you mean yes, not a materially analogous. And on whom is the burden of proof in relation to showing that? You or the other side?
At this stage, it's on the other side. It shifts when we get to justification. And yes, I recognise, of course, there are authorities to the effect that this can be an arid exercise, i.e. looking for the comparator. And there is, of course, in AB, a reference to looking to get to the focus quickly on justification. However, We do respectfully submit that each of those identifies that there may be cases that it can be clearly seen that the comparators fall outside the scope of the issue falls outside the scope of Article 14, or there are very obvious differences between the comparators, and we do submit that there is a proper point here as to the nature of the exercise that's being engaged in by the Home Secretary. But on the group, my Lord, referring to the tactics, the similarity of tactics, we respectfully submit doesn't amount to a comparator group for the purposes of Article 14. None of those observations amounts to an assessment that the Home Secretary reasonably believes that they are concerned in terrorism, which we submit would be the beginnings, what would be necessary for the beginnings of a comparator. There's in fact no suggestion of violence in the description in the CIA report. Still less, of course, any consideration of the 5 discretionary factors relevant to the Home Secretary's decision-making. The fact that they employ, quote, similar direct action tactics, we respectfully submit, doesn't establish them as an analogous group. Compare and contrast that assessment with the detail in the JTAC report, the assessments surrounding the Underground Manual, the escalatory trajectory of seriousness, etc., all of which we respectfully submit operates at this stage to remove any comparator group as between, on the one hand, Palestine Action and Extinction Rebellion, Justifications, etc., on the other. And we respectfully submit, again, the Divisional Court was right to identify that distinction at paragraph 144 of its judgment. But even again, if we were to take all of that, those points on behalf of the respondent and move to the question of justification.
What about paragraph 145? There's another issue. You've got a number of questions, material similar to this one, on grounds of race, religion, political opinion, and so on. 145 says that there was no indirect discrimination or direct discrimination. Are you relying on that or not?
I'm going to come to indirect discrimination.
There's 145, just indirect discrimination.
That is how I read it, but let me just... Yes, because it's a reference to race or national origin, I'm assuming that's an indirect. And I'll come back to that.
That's fine. You want justification?
On justification, not true. On justification, we respectfully submit that when one looks, in fact, at in particular, the March ministerial submission, the 26th of March ministerial submission, we do submit that one of the key strands of the analysis that was before the Home Secretary was the issue of whether there was a proper basis to distinguish Palestine Action from other so-called direct action groups. It was introduced, and you see it introduced, in the MinSub, page 147, electronic 156, paragraph 10. You'll see there reference to there being no known precedent of an organisation being prescribed on the basis of its concern in terrorism, mainly due to its use or threat of action involving serious damage to property. Paragraph 10, page 147, or E156. And a recognition the decision to prescribe will be relatively novel and unprecedented. And in essence, we respectfully submit that set up the issue for the Secretary of State in this context, which in fact was the question: what's the justification for prescribing Palestine Action when there is no prescription of, for example, Extinction Rebellion, Justifications, etc.? And that is a theme we respectfully submit that runs through the MinSub, as it had been at the PRG, as reported within the MinSub. So I don't think I need to take you through all the references, but I'd invite the Court to look at paragraph 18 in due course. Reference to the distinction of Palestine Action responsible for an escalatory campaign of direct action that has crossed the threshold into terrorism. Paragraph 19, a recognition at the PRG level that the public and international perception that counter-terrorism powers are being used disproportionately, the impact on certain communities. Paragraph 37, the PRG agreed there was a risk that the general public and international partners will question the proportionality prescription. They will likely ask whether PAG's activity is really terrorism. Similarly, 39, 41, and through to 53, a reference there to the overall narrative about Palestine Action being similar to that of Justifications and their activities, and they appear to be viewed as such by the media. criminal but not terrorist. So we do submit that when you get to the question of justification, that was, in one sense, the heart, at least the heart of part of the exercise before the Home Secretary, reflected in the ministerial submission quite properly, but also in the underlying reports. And that's, in fact, the proper context of the CIA report. And there's reference to in the Foreign and Commonwealth report on the fifth factor, recognising again some European countries may also question our decision on the basis for prescribing, and rather that it's an activist or protest group.
In a sentence, if you get to justification, you've got two groups that are similar. I know you object to that, but yes, they're both similar. And the argument is you picked on one and not the other. You banned one, you haven't banned the other. What, in a sentence, is the justification you say no to discrimination?
That they've crossed the line into terrorism, that they're responsible for an escalatory campaign that is increasing its risk, therefore, to national security, that the existing features of the criminal justice system aren't sufficient adequately to deal with the risk that's posed.
Back to fair balance.
And that, exactly, as the submission I'm about to make is that entire strand of analysis and evaluation is going no further than the issues already considered under Article 10 and 11, which is why we respectfully submit that ultimately it simply collapses back to where we are already. And in this procedural context, if we're here, you will have decided already that it's proportionate to prescribe Palestine Action, and the justification for so-called singling out Palestine Action will be within the justification under the Article 10, 11 challenge proper. So we do submit a legally far less certain route to the same question and the same answer. I can take indirect discrimination much more quickly. The issue on indirect discrimination resolves to the question as to how is it that any indirect discrimination is ultimately resolved. How is that issue ultimately resolved? We do have, I should say, our preliminary objection as to whether you can properly evidence any differential treatment. That was identified by the Divisional Court, paragraph 145. We stand by that, and the conclusion there, we would support that. But even if you're over that hurdle, and you're into the question of how do you justify what has been found to be indirect discrimination, that again collapses back into the Article 10 and 11 issues. Because in indirect discrimination, what has to be justified is the measure. And if we need that, it's in ALR, that's the Private Schools VAT Exemption case, paragraphs 127 to 128, Authorities Volume 2, tab 48, pages 1731 to 2. You have to justify the measure, and we respectfully submit that that takes you straight back to where you are already under proportionality, Articles 10 and 11, with respect to the main ground of appeal. That is, I think, all that I need or want to say on discrimination, unless there are any questions.
Thank you very much indeed. Yes, thank you very much indeed, Mr. Watson.
It is, my lords. Just by way of reply, in relation to the policy issue, we can go back to that if you can cast your mind back into that space. I wanted to make three short points by way of reply. The first is the focus that my learned friend sought to place or replace on the reference to the need for there to be a, quote, particular need to proscribe, derived from paragraph 91 of the judgment. And our answer to that, as I'm sure you're already aware, is that there is no such wording in the policy, and there is no basis for implying any such wording into the policy. What the policy in fact did was to acknowledge that there was a second stage beyond the organisation being concerned in terrorism. That second stage therefore involved a discretion, the may in the Act, and involved proportionality, and it was right to do so. And the correct approach thereafter is that in relation both to the discretion and to proportionality, I'll come back to the meaning of that word in a second, the right approach is that all relevant circumstances all relevant circumstances that bear on proportionality or discretion can be taken into account and fall to be taken into account. There's a slight difference potentially between the common law discretion and proportionality under the ECHR, but it matters not terribly for present purposes. And that is to emphasise that under the common law, the factors that are taken into account by a decision maker can encompass all of those that the Secretary of State or other decision maker might rationally conclude bear on the policy, but it doesn't terribly matter. And all of those other factors are included in other factors in the policy, as you will recall. You do not, therefore, under the policy, need to demonstrate some special need. There were, in any event, in this case, as you know, matters or factors that went beyond, and that were taken into account, that went beyond simply whether or not Palestine Action was concerned in terrorism. There were other factors. There was, for example, the fact of escalation. There was, for example, the nature of the other activities in which the organisation had been involved. Criminal, not criminal, injury to people. And there was, by way of final example, the underground manual. And my submission is that other activities must include, and properly does include, matters beyond simply those specific actions that founded the conclusion that the organisation is concerned in terrorism. That's the first point. The second point is to register a query, really. I'm not entirely sure where my learned friend's case got to in relation to all of this. At one point he seemed to be accepting that particular need equals proportionality. It was the same thing as proportionality. I don't really understand that submission anyway, because proportionality, as we're all very well aware, is a necessary precondition to the fulfilment by the public authority of its duty under Section 6 of the Human Rights Act in a context such as this. So what my learned friend then sought to do, I think, was to say, well, you have to interpret this reference in the policy to proportionality as meaning something going beyond what proportionality would mean in the ECHR sense. It imposes a higher hurdle or a stricter test for the Secretary of State to surmount, imposed, or rather self-imposed by the Secretary of State through the application of the policy. We respectfully submit that any such suggestion would be untenable. And I ask simply rhetorically two questions. How on earth can you interpret the policy so as to achieve the desired, we're saying, effect? In other words, that proportionality, when referred to in the policy, means something stricter than ECHR proportionality. And the second question, rhetorically, is even more practical, it might be thought. Why on earth would the Secretary of State self-impose that? That's the second point. The third point is that the real concern here with the Divisional Court's judgment, if I can cut to the chase of it, the real concern here is that the way in which they analysed the policy ultimately led them to two things. The first of them was to limit the Secretary of State's consideration essentially only to matters that are concerned in terrorism. And in relation to that point, a justem generis if you want some Latin, but in relation to that point, it is now conceded orally by my learned friend that that part of the judgment was wrong.
Well, he concedes that the similar nature bit was wrong, but he doesn't concede the terrorism point.
Yes, well, my lady, my submission is that other factors in the policy is premised on the organisation already being concerned in terrorism, so must refer to something additional, and does. That's the answer of substance if that submission is maintained. The second thing that their construction or interpretation of the policy led the divisional court to was the exclusion of any consideration of operational consequences or the advantages of proscription. That's the paragraph 94 point. And of course, the difficulty with that is the usual one, which is that the policy doesn't say any such thing, and there's no proper basis for implying that into the policy. But there are principled objections to that approach. And the principled objections include the point that I think my Lord Justice Edis put to me when I was opening the appeal, which can be summarised as being for and against. Relevance is a neutral business. And it would be very odd if an organisation was concerned in terrorism and the Secretary of State considered the advantages or disadvantages of prescription and decided that the disadvantages outweighed, that was a mandatory irrelevant factor, which is essentially what this argument comes to. And my submission is that it cannot possibly or sensibly be treated in that way as irrelevant or excluded under the policy. That's all I wanted to say about the policy by way of reply. I'll turn to Articles 10 and 11 then. And I'm going to come back to both of these points when I consider proportionality, because both of them echo into that world as well. But I'm going to start with the Article 17 submissions that were made. My submission is that Palestine Action, that is the organisation itself, and its activities, and what it encourages others to undertake on its behalf, are beyond the pale. And you get that particularly in relation to the ECHR from the analysis from paragraphs 82 and onwards in the Attorney General's reference case. This is not just under the statutory scheme damage to property alone, as I think Mr. Hussain at one point put it. The statutory test is serious damage to property, and the Court of Appeal have analysed the ECHR aspect of all of that in the Attorney General's reference. I make no further submission about that. So far as the supporters are concerned, of course it is right that not all supporters engage in the terrorist activity which Palestine Action has engaged in. My submission in relation to supporters as a group is that they are not within the scope of the protection of the Convention, because it is no part of the scope of Articles 10 and 11 to allow people to support, and by the various forms of support that are prohibited under our legislation, to encourage an organisation properly and compatibly classified as terrorist under the domestic legislation. And the vice of that support and encouragement has recently been very clearly acknowledged by the Supreme Court in ABJ. I'm not going to invite you to turn it back up, but this time the paragraph is 103 in ABJ in the Supreme Court, tab 49, page 1820. And we would add to that encouragement and support bit that it also involves people, if they trespass on those prohibitions, it also involves people committing criminal conduct under our domestic law. So that's essentially the basis on which we mount that more extreme version of the Convention argument that says they're outside the scope. I say both of those points will chime, even if that's wrong, when one gets to weighing and assessing the different sides of the balance for proportionality and fair balance purposes. I turn to less intrusive measures. The question, as I think we're all agreed, is whether or not any of the measures that might be suggested by a person challenging a decision would be as effective. You can put that as effective concept in a variety of different ways, as it has been in the case law. I'm perfectly content to accept no unacceptable cutting across the legitimate aim. It comes to the same point. My core point is that it's a relative concept. Answering that question, once you recognise that it's a relative concept, involves assessing risks. and working out how best to tackle an organisation that has been engaged in terrorist activities. And those are, of course, questions of judgment, ultimately, and assessment for the Secretary of State on advice. And for that reason, this judgment call also attracts margin. It was submitted by Mr. Greenall, who made the submissions on this aspect of the case. Two submissions were made, I think. First, this matter wasn't considered, he said. My answer to that is twofold. That's irrelevant for the purpose of the convention analysis because of the long line of cases that culminated in Lord Hoffman's famous judgment in misbehaving. A substantive breach of the convention focuses on the substance of the measure and its effects, not on the procedure by which it was reached. Second point is that it's perfectly clear that the possibility of alternative, less intrusive measures was considered. It was considered specifically in the CTP report that I took you to in opening. You'll remember the bit headed existing legislation and then the bit saying benefits of proscription. For your note, that's in the supplementary bundle, hard copy 175, soft numbering 184. And that considered, as you will recall, the range of criminal offences, criminal damage, offences under the terrorism legislation that didn't require prescription, criminal behaviour orders, serious crime prevention orders, all of that, and then compared and contrasted those with what you would get if there was prescription, by way of advantages or disadvantages. It was also considered in the ministerial submission of the 26th of March, and again I don't go back to that, but I remind you of it. Paragraphs 33 and 34 in particular of that, same bundle, hard copy page 150, electronic page 159. I wanted to give you one other reference because this issue of less intrusive measure was dealt with rather more fully below, at least in writing, and there is a little section of about 5 or 6 paragraphs in our skeleton below to which
there's also an issue which is not relevant but indicative perhaps of whether or not you could just prescribe Palestine Action London.
Yes, I think that was...
For a partial prescription.
Yeah, I think...
That was also rejected as being impracticable.
It was, and you'll see a few of these different ones being thought about. Can I just give you the reference to our skeleton below? It's paragraphs 50, 50 to 56, and the reference to that is core bundle, hard copy 276, electronic version 430. That'll take you, I hope, to paragraph 50 of our skeleton below. Some prohibitions that enabled action to be taken and prohibitions to be imposed that went to the organisation, if I can put it that way. So there was a particular benefit perceived in relation to dealing with those matters in that way, as it was called, I think, by the CTP, holistically. But you will also recall that the Secretary of State had advice from her experts, the PRG, the CTP and others, that there were benefits and this was the way to go. And I come back to the fact that that therefore engages margin, engages issues of judgment and so on. My learned friend Mr. Greenall renewed before this court as the point that he majored on below, which was in effect the combination of criminal offences and civil injunction. Criminal offences suffer from the difficulty that they are necessarily ex post, necessarily backward-looking, and do not enable the sort of holistic attack, as it were, on the organisation's capabilities.
I think Mr. Greenall was referring to the offence of conspiracy as an offence which could be committed and proved before there had been any actual criminal act.
My Lord,
such investigations do tend to be quite intrusive.
Yes, and sometimes quite difficult, and you've got to work out who's conspiring about what and all of that. So I fully accept the caveat, as it were, in relation to conspiracy and its forward-looking nature, that it comes with those difficulties. Again, these are judgments. But civil injunctions, I respectfully submit, are very difficult for my learned friend to rely upon. There are myriad effectiveness issues. They are complex. They're likely to involve and have to involve private companies who, as my lady pointed out, the lady Chief Justice pointed out, cannot be compelled to take action by the Secretary of State. So this isn't state action at all. Sometimes the state can assist in various ways, but the litigation is ultimately driven and directed by private companies if they can be persuaded to do so. And of course that's rendered all the more difficult when you factor in the context here. You will remember from the documentation the disparate range and increasing range of targets that Palestine Action was going after. And that, of course, enhances the difficulty and complexity of seeking to address any of these issues through the civil injunction route. The reminder is to JTAC's report, paragraphs 49 to 50 in the supplemental bundle, 166 in the hard copy, electronic 175 in the supplementary bundle. That's less intrusive measures. And I come to fair balance. The question, ultimately, is whether or not prescribing Palestine Action is an action which struck a fair balance applying the margin. Palestine Action is the core focus, and my submission is that the answer is very clear indeed in relation to Palestine Action. My learned friend opened his submissions, Mr. Hussain opened his submissions, by in effect maintaining the constant plea to civil disobedience being an appropriate descriptor or analogy. That is untenable, I submit. You have, in relation to that, the judgment of the Divisional Court itself, paragraphs 21 to 23, giving the lie to that description and specifically rejecting it. Can I just invite you to go back to the case that he seemed to place principal reliance upon, which was the Margaret Jones Authority. That's in the authorities bundle at tab 1717, and it starts at page 478. And he simply referred you to what he described as the classic paragraph of Lord Hoffman 89, which is at page 519. Can I just invite you to cast an eye down 89 itself, because the seeds of the point I want to make by way of reply are contained in that very paragraph. The reply point is there are limits, as is evident from paragraph 89, but you see that very clearly if you read the judgment as you have to, both before and after that paragraph. Go back, for example, to paragraphs 83 identifying the mechanisms which the citizen is legitimately entitled to take in the second half, making the very clear statement that the law will not tolerate vigilantes, and referring to the circumscribed nature even in relation to the person defending his own property. 84, second sentence, citizen not entitled to take the law into his own hands. The rule of law requires that disputes over whether action is lawful should be resolved by the courts. Citizen is dissatisfied with the law as laid down by the courts. He must campaign for Parliament to change it. And even clearer when you see the paragraphs that follow and expand on the nature of the limitation that was inherent in paragraph 89 itself. you need to read 89. I'm not going to invite you to do it now, but you need to read 89 with the qualification, if you will, the identification of the limit in paragraphs 91 to 94 on page 520. And in effect, what is being said is that the limit is commission of crime. And the reason the limit is the commission of crime is because there are other mechanisms, proper mechanisms in a democratic society, for raising issues of concern, political or otherwise. To that debate can now be added the ECHR context and analysis that we saw when looking at the Court of Appeal's judgment in Attorney General's reference number 1 of 2022, Lord Burnett's judgment in that case, and I don't go back to that. But it's on the same theme. What are the limits that the ECHR imposes on all of this? So it's entirely unsurprising, I submit, that the Divisional Court in paragraphs 21 to 23 decided as they did. So that's the disobedience, civil disobedience characterization. Linked to that, and perhaps the second point in relation to Palestine Action, that side of the scales dealing with Palestine Action itself, you have all of the references that I gave you, almost all unchallenged, in the judgment itself, in opening the facts when I gave you the title, The Nature of Palestine Action and Its Activities. I'm not going to go back through that, but you have all of the facts that I identified then as giving you a proper flavour of the actions that Palestine Action had chosen to undertake, including, I would add, if I may identify 3 paragraphs in particular for your repeated consideration, 29 to 30 of the Divisional Court's judgment, and in particular 137, where they describe in 137, it might be as well to just briefly turn that up to remind you, 137 of the Court's judgment. And in particular, it's the passage from halfway down that paragraph, the line beginning 2000 Act. You see the sentence, any such action is the antithesis. From there to the end of that paragraph is a key summary. Just by way of responsive points to the points that my learned friend made, I wanted to make 3 responsive points briefly on the facts as they relate to the activities of Palestine Action. The first is that my learned friend Mr. Hussain sought to maintain a case that the government did not previously think that the terrorism test was met in relation to Palestine Action. And my answer to that is that any government is entitled to review and to re-review a question of that kind. And we note in particular in that respect that the evidence on which the Secretary of State and the advice on which the Secretary of State acted before prescribing included a detailed analysis from JTAC and a detailed analysis from the CTP, the Counter-Terrorism Police. But whether any of that is necessary is questionable, because there is no dispute now, and there never has been a dispute on behalf of those who represent Palestine Action, that Palestine Action's actions did indeed meet the statutory test, in fact. And I made the submission in opening that the 3 incidents that were particularly relied upon for that purpose were supplemented by the Brize Norton incident. The Brize Norton incident being important in its own right, but also important because it indicated the tempo of escalation escalation that had been predicted before it occurred and then came to pass.
Mr. Hussain lays great weight on the 3 out of 385 and the length of time over which the incidents took place. Do you say anything about that?
My lady, I do. I'm going to come back to Brize Norton in a second when I've answered my lady's question. But the incidents in question, I respectfully submit that an organisation can involve itself in terrorism in a serious way, despite the fact that it's conducting a load of activities outside that may or may not fall within that definition. And what matters is that they have done so. You have the divisional court's findings in relation to all of that, including that they weren't aberrations. They weren't either a mistake or an aberration. I go back to paragraph 137. And I go back to the point that those actions were lauded by Palestine Action and were the subject of encouragement by them, as the divisional court found. So I respectfully submit that it's not the numbers that matter so much, but the nature of the incidents and whether they meet the tests that Parliament has laid down. So far as the age is concerned, no doubt there will be some cases, and in some contexts it will be more relevant than others, where a particular allegation, or for example a particular piece of intelligence, is very old and therefore falls to be discounted accordingly. But these incidents are not in dispute, and they exist in combination, and they sit alongside the escalation, they sit alongside the underground manual, and they sit alongside all the other activities on which reliance is placed. Just back to Brize Norton, if I may, briefly. That incident did not feature in the JTAC assessment for the obvious reason that it occurred after it. And there was no need, therefore, formally to rely upon it, but it undoubtedly was relied upon. Palestine Action themselves claimed the glory of it, if that's the right way of looking at it. They claimed responsibility for it. And it was evident.
Where's the evidence of that?
I'm not sure it's ever been in dispute, that. I'll see if I can get you a specific reference to that. But it's clear in any event that it was a serious incident, and that is how it was characterised in our skeleton below. I think my learned friends ought to say, well, there's never been any reliance by me or my client on the Brize Norton incident, and he referred you, I think, to paragraph 59 of our skeleton below. Again, without wishing to be too tart about it, you might choose to read paragraph 60, which directly follows it, which refers to the Brize Norton incident and the seriousness of it. The reference for that is Core Bundle, page 279 in the hard copy, page 432 in the electronic. That describes, I think I gave you this reference earlier, the evidence that describes the Brize Norton incident and Palestine Action's involvement in it is in Sinclair 2, never controverted, Sinclair 2, which is in the supplemental bundle, number 1, and the hard copy page number is 42C. I'll get you in 1 second the electronic number. For a moment, I haven't got the electronic number. Can someone get me the electronic number? 45 in the electronic. 45 in the electronic number.
Sorry, what were we looking for?
We were looking for the for Sinclair 2, describing the Brize Norton incident.
Palestine Action that I was concerned with.
Yeah. That's the first point by way of response. Second point is to remind you simply of the Divisional Court's findings in relation to the underground manual on which my learned friend sought to place some reliance.
So, James, just before we go there, could I just ask, are you saying that the Brize Norton incident was itself a terrorist act, or merely that it was evidence of an intention to continue and escalate previous behaviour?
My Lord, I'm not sure we've ever really come off that fence. It could be either. The only reason I'm reluctant to come off the fence is because we haven't got the formal assessment that we had in relation to the other three from JTAC. But I think we described it in paragraph 60 of the skeleton as obviously a serious act of damage. I mean, it doesn't terribly matter for my purpose whether it's one or the other, unless one starts drawing strict distinctions between those acts that have been formally characterised as concerned in terrorism and those that haven't, which I respectfully submit cannot be right.
Thank you.
The second responsive point was to deal with the underground manual, and it was simply by way of reminder. See judgment of the Divisional Court, paragraphs 23 to 27. And the third responsive point was to indicate, and perhaps it's on the same, it's really on that same theme about some things being on one side, some things being on the other. It doesn't terribly matter where you put them ultimately, if they are seriousness, because you'll be aware that at least in relation to some of the incidents, there were serious concerns about violence against people. You'll recall the sledgehammer incident, and you will recall particularly that the passage that my learned friend took you to in the supplemental bundle, just go back to it very briefly if you would, just to remind you, at electronic page 242 in the first supplemental bundle. That's hard copy page 233. And this, as you will recall, is in the counter-terrorism policing report describing the various incidents. And my learned friend, Mr. Hussain, took you to the passage, notionally by the second hole punch, so it's the last paragraph that isn't blanked out on page 242 electronic. This is a step up. And as I think my lady alighted upon a reminder of my learned friend, this was indeed a step up. So it was illustrative of escalation and perhaps the porosity of some of the lines between characterising serious action as one type of thing or another. But also, and perhaps of some real significance to note, is the paragraph 2 above that, right in the middle of the page, beginning in summary. And I think if that is put as an example in combination with the second half of paragraph 137 of the Divisional Court's judgment, that rather provides the answer to the question my Lord Justice Edis posed to my learned friend. Which was, these aren't isolated incidents, these are matters of real seriousness. So it's against that background and backdrop that I made the submission, and I repeat the submission by way of reply, that the assessment that is undertaken under the policy, under the convention, matters not, encompasses and must encompass both the activities that fall within the definition of terrorism and other activities, the entire range of activities, for good or ill, but the entire range of activities, mostly ill, we respectfully submit here. But the latter, the range of activities outside that statutory definition, of activities outside that definition, are in principle relevant. It's unsurprising they should be so, because the fundamental purpose of the prescription regime is protective. And of course, those other activities and a broad assessment of what the organisation does is central to a proper assessment of risk. And risk is the determinant of the protection of the public for present purposes. And on that facet, we do submit that it's of particular importance that all of the experts advising the Secretary of State concluded that proscription was appropriate. All concluded that the actions of Palestine Action were escalating in seriousness, tying it back to judgment paragraph 137. All were concerned about the way in which they conducted themselves, including through publication of the Underground Manual, the cell structure, the violent activity being encouraged, and so on. It is no answer to that concatenation. It is no answer to that to say that many of his activities were, to use the wording of the Divisional Court, quote, merely criminal. Merely criminal will put it beyond the pale for the purpose of the domestic common law. See Lord Hoffman and Margaret Jones. And if you're dealing with violence or criminal damage above the merely trivial, that will put it beyond the pale for the purpose of the ECHR. See, for that purpose, Attorney General's reference. And that is why we respectfully agreed with, and agree strongly with, the description of Palestine actions and activities in the round by the Divisional Court at 137, describing them as the antithesis to the notion of a democratic society that is the foundation of the ECHR. That's the position in relation to Palestine Action, therefore. That's one side of the scales, if I can put it that way. The other side of the scales is the impact on supporters. But it's important perhaps to identify the right question when you get there, because it's Palestine Action that is being proscribed. The question at this stage is whether, if viewed by focusing on the subject of the proscription, namely Palestine Action, the answer is clear, as in my submission it is, for all the reasons I've gone through. Is a different answer required under the Convention because of the possible effects on others? That's ultimately the question, and I want to make 2 points in relation to that. The first point is that all of the reliance on the impact on supporters, if I can put the groups in that broad way, were, as the Divisional Court themselves found, considerably overstated by those presenting Palestine Action's case. And I gave you a whole series of references yesterday to the passages in the judgment that reflect that, including, I may add, and I'm not sure this was one of the list, the conclusion at paragraph 118 of the Divisional Court's judgment that the correct conclusion in relation to those holding up the banners post-proscription was, quote, calculated action. But as importantly, the other chilling effects were, they concluded, overstated. And I would add at that stage that the category that my learned friend Mr. Hussain then sought to rely upon in his oral submissions in particular were those who had not been members or supporters before, and they wanted to advocate for its deproscription. And the answers in relation to those are, firstly, that they have no prior attachment to the organisation itself. And that's a point that's important for a reason I'm going to come to when I do my second point. No prior attachment to the organisation itself. But secondly, that it's perfectly possible to have a debate about deproscription of an organisation compatibly with the law. ABJ being the font of all knowledge, can I give you 2 further references into ABJ for that purpose? Paragraphs 47 on this specific point about whether you can call for someone to be deproscribed, leaving aside the technical point that says if you can demonstrate that you're a supporter or you want to get it deproscribed and you've got a sufficient interest, you can apply yourself to POAC or to go down that road. But ABJ 47 and 79 are the paragraph numbers in ABJ for this purpose, and you find them at 1804, electronic, and 1813. That's the first point, considerable overstatement, proper reflection of the true degree to which impact actually happened, found in the judgment of the Divisional Court unchallenged. Second point, and this is absolutely critical, I respectfully submit, it is necessary in the convention analysis, when considering the impact on others of the prescription of an organisation that has involved itself in terrorism, to be very, very clear about the distinction between support for a cause and support for an organisation that might be involved in orchestrating or organising protests in support of that cause.
And that is para 61 of ABJ.
Para 61 of ABJ, but support, I make the more general point that the support for the, it's 60 and 61 of ABJ, it was ahead of me, but support for the cause is the core of the protected right. The free speech.
What does that mean?
That means that the free speech that is truly at the heart of the protection that Article 10 provides is the speech that advocates changes to policy, political speech, indicating public approval or disapproval of various matters. That's the core of it. That is the broad political speech and issue that underpins Article 10 and indeed the freedom of assembly right in Article 11. That's at the heart of it. And that core is untouched, absolutely untouched. You can continue to advocate anything to do with that. That's the point that the Supreme Court was making in 60 to 61 of ABJ. So what are you left with in terms of impact and weight to be accorded to these rights? You're left with support for the bare organisation. And we know you can't do that post-prescription. But that is because Palestine Action is justifiably viewed as proscribed with the legal consequences that Parliament has judged to be appropriate. But it's very hard to see why, properly separated and distinguished from the cause, much if any weight is to be attached to the mere support of the organisation. It is simply a strident advocate for the cause that you continue to be. You can continue to be a strident advocate for on your own or through some other organising body that organises marches or whatever else it may be. It's very much the point I was discussing with the Master of the Rolls yesterday when you put to me essentially this distinction. And I respectfully...
but I think the problem, or the point that I was putting to you, is that whilst intellectually you might be able to make the point you've just made, the people who support Palestine Action and hold up the placards with those words on them don't understand the distinction and are affected inevitably by prescription. And what I was putting to you was that that is something the Secretary of State had to take into account, that we're dealing here with real people who are affected by her decision, and I'm not saying it's a conclusive factor in the balance, but it seems that it is, and I think you accept it, it is a factor.
Oh, I do accept that that's a factor. I'm not sure that's quite the point I was accepting yesterday, but I'm perfectly prepared to accept that it was a factor. One needs to be a little cautious with going too far with it, because if they're holding up the banners post-proscription...
As a calculated action.
That's a calculated action.
It shows signs of a very clear understanding, not a lack of understanding.
Exactly so.
There may be people who genuinely don't make the distinction and aren't taking calculated steps. That's what we're looking at.
And it's a real effect here, because there has been, as you will have seen from references in the judgment and in the evidence, there's been quite a concerted campaign to swamp the courts and all of that. So they're trying. There's a deliberate attempt to undermine things in that way. So I don't need to resort to the idea, often referred to in these cases, that everyone is presumed to know the criminal law. But because the fact of the matter is that when they hold up the banners of the kind that my Lord has identified, and there was no problem with holding up the banners beforehand because they weren't prescribed, but after they're prescribed, you've got a finding that it's calculated action. So my point isn't a bare intellectual one, if I can come back at my Lord only in that respect.
No, I understand that. The other point is that Mr. Hussain made quite a lot of the fact that there were only 3 incidents. My lady has already slightly put it to you, 3 out of 390, and everybody else, he implies or infers, is not involved in terrorism, concerned in terrorism. And the question I wanted to ask you concerned what you said. I think it's paragraph 19 in the Divisional Court's judgment, where they said, I may have got the paragraph wrong, but where they said that information about how Palestine Action is organised and run is sparse, and there is no information about membership. I think membership is mentioned in 18. The extent and nature of Palestine Action's membership and organisation is largely unexplained. And I just wanted to know whether you relied on any other evidence about, it's all very well to infer that if there's only 3 terrorist incidents, there's only a few people, I think Mr. Hussein said 45, 35, I can't remember, people involved. What I wanted to ask you was, where does that evidence come from? It doesn't seem to be challenged.
Where there's the evidence in paragraph 19?
18 and 19, that there's nothing, that actually, when the court considered this case, they didn't have any evidence about the 400, 500,000 people who may have signed up in some way on Twitter.
Mr. Morley's witness statement, I think in part, you'll see the description in the second sentence of 19
right.
is coming from the claimant, and the second half of that paragraph in relation to the cell structure and the deliberate attempts to keep it, as it were, difficult to penetrate, it comes from the underground manual principally.
So it's a comment on those pieces of
comment in effect on those, or it's a conclusion from those pieces of evidence. But I mean, the point remains that there are, as it were, the 3 that were classified, incidents that were classified, but they were serious, and I've made my points about the porosity that may exist between criminal damage of a seriousness when you're encouraging them. You've got all the findings that say these weren't isolated, they were encouraging them to do, in effect, violent things, and don't be surprised if violent things spill over into other violent things. So it's all of that that we rely upon. But ultimately it comes down to essentially the same core point, which is a point about risk analysis and how best the public protection is to be achieved. And that does absolutely squarely fall within both squarely raises both the importance of the expert advice that the Secretary of State gets and the importance of the Secretary of State being democratically accountable for the protection of the public. So the outcome in my submission, ultimately, of all of this, is that it is very clear on the left-hand side, when you look at Palestine Action, what the answer is on proscription, or at least what an acceptable within the range of margin answer might be, and that in the light in particular of all of the detailed findings that have been made by the Divisional Court about impact, and when one bears in mind the distinction that I've just drawn, which is a real rather than a purely theoretical one, in relation to impact, you end up with a pretty strong balance in favour of proscribing and protecting the public that way. So that's how we put that part of the case. I wanted to turn briefly to the cross-appeal, the prior representations point, and I start with the principles, if I may. My submission is that prior consultation is an aspect of fairness. The governing principles are indeed, therefore, those 6 features of a fair process identified famously by Lord Mustill in Doody. What fairness requires when statutory powers are being exercised is context and fact specific. And as Lord Sumption himself acknowledged in paragraph 31 of Bank Mellat, such imposing a duty of prior consultation in relation to decisions made under such powers, quote, cannot be answered in wholly general terms. The test in effect identified in Bank-Mellat for determining whether there is a duty of prior consultation has two limbs. The first of them involves an exercise of statutory interpretation. Does the statute expressly or by necessary implication exclude the obligation to give prior notice and an opportunity to make representations? That's the issue on which the Supreme Court divided with Lord Reid in the minority for that purpose. Alternatively, if the duty is not excluded, do the circumstances in which the power is to be exercised render it impossible, impractical, or pointless to afford such an opportunity?
You say the Divisional Court effectively decided it was implicitly excluded in answer to question 1.
Sorry,
do you say that the Divisional Court implicitly concluded that the statute necessarily excluded the duty?
And also, yes, is the answer to that. And also,
they referred to the right test at the beginning. Yeah. That's your point. It is a bit less clear.
It is, and then
the later section of the judgment.
Yes, there's also a bit of an element in my alternatively bit, i.e., the impracticality and so on, coming from Lord Newburger 179. And my ladies, at least, will need no reminding of the application of those principles in the Begum context, including the important aspect of the context there being the need.
And what do you say in Begum where there was a right of appeal? What do you say without there being a right of appeal here?
Well, my lady, my submission is that the principles you identified and the approach that you took there, 106 to 108 in particular, didn't ultimately turn only on that. It was a broader question of context. And of course, we don't say that the factors are identical here. Of course, they're not. You were there dealing with the deprivation of citizenship and in particular the risk that the person would come back covertly, I suppose.
You're also dealing with specific people. In Bank-Mellat, it was one bank.
Yeah.
In Begum, it was Begum herself. Here you're dealing with a disparate group.
That was a very important point.
Yes, there's no corporate structure as such.
That was a very important point that the Divisional Court placed reliance upon. Can I come back?
Sorry, yes, do, but where did they do that? Just in their...
It's really 58 and following. Okay. I'm sure I'll get to the references to that specific one, if I may. I was going to start with the point about the identification of the principles by the Divisional Court. And my respectful short submission in relation to that is that they correctly identified the relevant principles. See paragraphs 47 to 55. And I'd say no more than that. I respectfully submit that's the correct identification of the principles, and then they come on to identify the factors as they bear on Palestine Action at 57 and following in the judgment. And again, my overarching submission in relation to that is that they were perfectly entitled to reach the conclusions that they did. They observed that the context in which the statutory power in question was being exercised was a critical consideration. That's 58 of their judgment. That was a conventional application of the requirement in duty that fairness must be assessed in all the circumstances, and in Bank-Mellat that it depends on the particular circumstances. The statutory context here involved national security and public safety and protection.
Do you accept Mr. Hussein's point that there's no blanket waiver when you're looking at national security? It's a factor.
It's a factor.
But yeah, okay.
I mean, you can't just turn up and say national security and that's it. But it is a very important factor, both national security and the protection of the public aspect of it. And my submission is that the Divisional Court were entitled to and correctly took into consideration that context. It meant, as they found at 58, that they should be cautious before supplementing the express procedural requirements imposed by Parliament. They were correct to note, I submit, in 58, that any decision to require further procedural steps in this case would necessarily apply to all other organisations when the Home Secretary was considering use of the power to prescribe an organisation.
Well, Mr. Hussain says no. He says that in this case it did, but in another case perhaps there wouldn't be a requirement.
Well, my lady, I'm not sure it's quite as simple as that. My submission is you are entitled to, as I think you did in Begum, you are entitled to acknowledge that this is, if you're looking at the statutory interpretation point, this is ultimately a question of statutory interpretation that will apply. Do you imply it or don't you? You don't imply it sometimes, as it were. And so there is that more general element. It doesn't mean that you don't go on to consider the facts here, and it doesn't mean that the divisional court didn't do precisely that. They did go on to consider very specifically the facts here, but it is important to bear in mind that ultimately this is an issue of statutory interpretation of general application.
What you're meant to treat like cases alike. If you've got an organisation like PA, and it's enough to pick one person who was one of the founders, or a spokesman whose email you've got, and that's enough, and it's not unlawful because you haven't contacted all the founders or all the people on the email, then if the same facts arise in another organisation's case, you'd have to do the same thing.
Yeah. Well, although those are the sorts of factors that they then go on to consider. The nature of the organisation in question, the organisation here concerned in terrorism, the extent of possible communication, the possible reaction of the consultee, the difficulty in practice of consulting an organisation of this kind, all of those matters which I respectfully submit are relevant to and bear on the fact-specific aspect of this question. And they led to the conclusion at 63 that the factors weighed heavily against the existence of a right of the kind indicated. It's also to be noted in that respect that they also identified in 62, halfway down, the possibility of preemptive steps, and my learned friend Mr. Hussain referred to that, in relation, for example, to the movement of funds.
But he says that there would always be that opportunity due to the affirmative resolution procedure. There's always going to be time.
Well, there may always be time, but the mere fact that you have more than a scintilla of time doesn't undermine the force of the point. It might take a while for people to clock it, it might take a while for people to react and to do things. But the position under the various bits of legislation that bear on this is that once an organisation has been proscribed, funds can't lawfully be raised or used for the purpose of that organisation, nor can any arrangement be entered into which facilitates the retention or control by the organisation.
But his point is that it's built into the system here. They will always know what's coming because they can't just make it and announce it. It doesn't take effect until it's approved by affirmative resolution by Parliament. They'll always know about that. And if there really is a problem, they're going to switch the funds overnight. There's the emergency procedure, the urgent procedure, forget what you called it.
Well, there is. There's the urgency procedure, and there's the practical point that they may not be set up in quite the way that would enable them to react in that way.
Well, they might not read Hansard, I suppose. Really.
They might not read Hansard.
They don't know what's going on.
Yeah. But anyway, there is a point there about preemption in any event. So we respectfully submit that's of some importance, and they note that at 62. They also particularly place reliance on the practical difficulties of inviting prior representations, identifying who should have been given prior notice. That's the point my lady was putting to me. Yeah. I think that's 65.
What about 61? Which is the process of consultation. It's the nature of the information on which one's consulting. And the need for caution and whether or not you could just sort of tell the whole story and ask for what sort of consultation would it be?
Well, my lady, I respectfully...
Did you share all the information, all the intelligence that you had? Clearly not all of it, some of it.
You certainly couldn't do all of it, and then you'd have to do summaries and you'd have to do everything else that is associated with this sort of context. I mean, they are all legitimate points. You might think that none of them is in itself conclusive, but my core point is that there's nothing wrong with this analysis. They're looking at the right things, they've identified the right principles, and they reach what I respectfully submit as the conclusion they were entitled to reach. And that doesn't involve any reversal or conflation or difficulty in relation to the approach that was adopted. They're doing faithfully the exercise that the case law identifies should be done. Look at the statute, look at the features that bear on the statute, and go to necessary implication. Look at the practicalities, look at the difficulties with doing it, and the difficulties here are myriad, and they are the ones that the Divisional Court identified. So my submission, in short, is that they were entitled to reach the conclusion they did on this issue for the reasons they gave. That's what I say by way of reply to that point. That's me done.
If I can see. Thank you very much indeed, Sir James. Anybody on your side following at this stage?
I hope not.
Anybody from the
I hope
second
not.
row?
I might have failed badly enough for that. But.
Right. Thank you very much. So, Mr. Hussain, reply on the cross-appeal.
Reply on the cross-appeal. I'll start with due process, if I may. And I want to make an overarching submission. And I mean it without any disrespect whatsoever to Sir James or the court. The court's approach and Sir James's submissions are entirely unprincipled. They get the test 100 degrees the wrong way round. Sir James said he embraced the court at 58, saying that you've got to be cautious before supplementing. A lot of the submissions were directed at, well, should the court really supplement? That's totally wrong. Even the old language about the court supplementing the omission of the legislature doesn't help, because the issue is, when do you do it, or when do you find that the right is implicit in the statute? And the answer to that question is that you find it's always implicit in the statute.
I thought your case was it was implicitly excluded. You
No.
say the foundational rule
Yes.
is that if something's going to affect you adversely, you should be entitled to consultation. And that's why the first duty question is, did the statute necessarily exclude?
Exactly.
All right?
So
it's necessary exclusion.
Exactly. The starting point is, it's there. If you're an ultra vires theory of judicial review person, you say it's implicit there. You're giving effect to the legislative intention. You're reading general words as if they include the right. If you're a rule of law judicial review theorist, you say the common law supplies it. Doesn't matter whether it supplies it or whether it's implicit. The question is, when isn't it there? And it's the starting position is it's there or it will be supplied, not is there good reason to supply it. It is there compelling reason. As a matter of logic, Lord Hobhouse in Morgan Grenfell, a necessary implication is a matter of logic and interpretation, not expediency, not reasonableness.
Did he say logic?
Yes.
Right.
Yes, he did. We haven't got it here. I've read it some time ago. But absolutely, he says logic. Because it's got to be necessary. It's a strict test. Because what you're doing is using general words to cut across a fundamental right in the technical sense, a basic right in the technical sense. It attracts the principle of legality, this common law rule. Statutes are presumed to respect the common law. You don't legislate in a vacuum as Parliament. That's Lord Brown Wilkinson in Pearson. It's really basic stuff, certainly in modern law. There are earlier, older authorities which are not so clear about that. But we have, I thought, it was common ground, Bank Mellat. It couldn't be clearer. 179191 of Lord Neuberger. The exclusion has to be clear, not the reason to include it. So it's totally the wrong way around. First question. Second question. The second point. Sir James said this twice. The question isn't whether or not the divisional court were entitled to reach the conclusion they did. It's whether they were correct, because this is a question of law. Short point. And then, my ladies, my lords, there are some there's some extraordinary reversal and emptying of the Lord Neuberger 179 test. If you look at whether or not it's going to apply in hypothetical circumstances, you have emptied 179 Roman 2 of application, because that is the test that picks up individual cases. The first limb of the test is what I've been going on at you about at over length in this submission. It's necessary inclusion. And it's absolutely heretical to suggest that if you imply it in this case, you've implied it for all. Sir James embraces paragraph 58, where the court says this. It would be necessary to apply it to all organisations. My Lord Justice Lewis says, well, you find that there was a co-founder of another organisation. If you found the co-founder of Al-Qaeda, you might just have a reason on the facts of the case to say, no, I'm not going to tell them.
That's for any organisation, the presumption is you consult them, and if there's somebody who you can consult, then you do consult. That's the point. You can't start again in each case, can you, and ask again, is it a good idea, should it be excluded or not? Well, the starting point is there's got to be a reason on your analysis.
Yes. The default rule, the very strong default rule, is you consult. This is a draconian a power as you could get. And my lord, the other point of distinction that you were trying to sort of raise with Sir James, or did raise with Sir James, is that, well, in these other cases you've got an individual, here you've got a group. You've got an individual here, my client. Her rights are dramatically interfered with. And then you've got everybody else. The position can't be worse as far as the common law rule is concerned, if you've got hundreds of thousands impacted than if you've just got one.
No, but the question is, would it be lawful? Is it lawful to consult one founder but not the other founder? That's the difficulty. I mean, are they going to have
That's a practical question. 179(2).
What's the answer in this case? Is it unlawful?
No, the answer in this case, absolutely not. Those are my instructions, I'm sure.
Well,
and we've said it. My lord, this is 1792. You deal with practicalities, difficulties. Oh, well, let's say there are 10 co-founders. Do you have to consult all of them? Are they going to say different things? It's impossible to raise them. Well, you do your best, and B, if it's impractical, Lord Neuberger, 1792. What does he say in the final sentence of 179? You've got to be very slow to exclude the duty to consult under Roman 2 by reference to the particular circumstances, because by that point the statute hasn't excluded it by necessary implication. So really, what's gone on here is a reversal of the correct approach. Begum, a couple of points on that. 2 points. 109 is key. Your ladyships say that what SIAC had done was to underrate the importance of the appeal. The appeal was very important. Second point, Begum is Morava territory. It's absolute Morava territory. If you give notice, the point of what you're doing is gone. This statute is very different. It's very different because the delay is built in, and Parliament has said, when you've got a problem with the standard procedure, no doubt because it will give rise to give notice of what you're about to do, use the urgent procedure. How can that, by necessary implication, exclude this fundamental right? This is a very important point. Just because you've got a terrorist context, we say marginally engaged, it doesn't mean you just forget about this fundamental protection. On the contrary, it's where you should be most live to honouring that tradition. It's quite extraordinary set of submissions, if I may say so, on a very, very important point. Those are my submissions on that ground. On the discrimination ground, 4 points. Firstly, sorry if I'm repeating myself slightly, the reliance by my learned friend Mr. Watson, King's Counsel, on the nature of the decision is heretical. Proscription, presumably all discretionary powers fall to be exercised on a case-by-case basis. To put that beyond the reach of equality law, we say is obviously wrong. Second point, he says, well, the cases concern systems and cohorts. Well, Belmarsh concerns a decision to detain some people suspected international terrorists as defined by Section 21 of the Act, and not others. Second point. Third point, it's not an impossible burden. In any event, it absolutely doesn't arise in this case because the Secretary's own advice was that these other organisations employ, quote, similar tactics for the purposes of proscription. And if there wasn't an assessment about the level of violence, the level of damage they cause, well, that is evidence of discrimination, not an answer to it. The fourth point, the ministerial submission says nothing whatsoever about comparators, doesn't even attempt to justify the difference in treatment. The submission ignores the difference between justification of the measure and the justification of the differential. And that's a profoundly important difference in equality law, in our law. And where is the evidence? If that's the case, where is the evidence? Please. Where's the evidence? We didn't think they were analogous, and by the way, they're not for these reasons. You had the opportunity, you sought the opportunity to put an evidence, you didn't avail yourself.
And I think we had that.
You've got the point. I'm so sorry.
No, don't worry at all. Don't hurry, it's absolutely fine.
Last point. On these 2 grounds, we don't have permission. This is a rolled-up hearing. I would ask you, please, to grant us permission, whatever you do, in terms of the substance, not least because we would say that the submissions are good. We'd say at least they have a real prospect of success, but we'd also say that there's a compelling reason. And your ladyship and my lords may remember why that's so important, as Lord Justice Lewis reminded me at about 10 p.m. on that day, the 4th of July. If this case goes further, then whether or not you've granted us permission on these grounds is important. Those are my submissions.
Anything else? No, thank you. Thank you very much indeed, Mr. Hussain.
Thank you.
Anybody else fancy standing up at 4:10, having a go? No. Well, we need to deal with some housekeeping and some reporting restriction issues, but it's the right moment to thank everybody in court for all their hard work, for their very helpful written and oral submissions. And could I also take this opportunity to thank all of the court staff who have been magnificent in preparing for such a big hearing, and indeed our clerks and everybody behind the scenes. We have had a veritable tsunami of documents and emails and materials. I'm sure it's been hard work on your side, but it's also been hard work on those who support us in the work that we do. So we are all very, very grateful indeed for that. So unless there are any other matters, before we turn to reporting restrictions, of course, formally we should say that we will be reserving our judgment. We have a closed hearing as a matter of public record tomorrow morning. That must start promptly at 8:30 because one member of the Constitution at least will have to leave court at 10:30. So please make sure that everybody is really ready to go at 8:30 tomorrow morning. We will, as I say, reserve our judgment. We will keep the parties informed. There will be the usual processes to go through in terms of any closed submissions or material, and we will keep the parties informed as best we can. Obviously, there is an awful lot for us to think about. We are aware of the urgency. We'd be very grateful for Sir James if you keep us informed of any developments in Scotland that may be relevant to timetabling or other matters. Are there any other matters in terms of housekeeping or procedure that anybody would like to raise? And can I just check with my Lord and Lady if there's anything I need to deal with? I think due course, when we have a clearer idea of how we're going to deal with hand-down arrangements. Yes, Philippa. Yes, well, we may well not be handing down anything under embargo. If we do, you don't need me to emphasise the importance of compliance with the embargo, and a failure to comply with the strict terms of an embargo can result itself in criminal offences. So, as I say, we will keep in touch closely as to what arrangements we make for hand down. Right.